Mariana and others, and BHP and another parts code.
Mr. Toledano, I think before we hear from you, we have a couple of points we would like to raise with Mr. Gibson. One, and I'm afraid this is hearsay on my part because it hasn't reached me, but I'm sure problem with our end, not yours, but I gather that we were sent last night a form of undertaking, though not, I think, a recent form of undertaking. I think the date on this is the 13th of March. But it wasn't clear to my colleagues who've read it, or to me, having been told about it, why it was being sent and why it was being sent last night and what its purpose is. Can you just explain?
We submit it's not necessary, my lord, but in case it should be thought it's necessary for reasons which I'll develop in the FNC arguments, we wanted this possible further undertaking to be deployed before the court, because in their skeleton, the claimants had taken a point about the lack of an undertaking of this type.
Thank you. I see. Thank you. That's very helpful. We will. So we'll hear from you at the appropriate time when you're dealing with foreign non-conveniens. The second point is this, and again, not exactly hearsay, but one of the other members of the court are more on top of this than I am. But it is not at the moment clear to us what the position is about and what your position is about the pending appeal which seeks to challenge the jurisdictional basis of the novel system. Our understanding is that it has been interim relief was refused, but unless you tell us to the contrary, the substantive appeal is still pending, with the possibility of a further appeal thereafter. And so far as we have been able, this comes from Professor Rosa's evidence. So far as we've been able to identify in your evidence, the only relevant evidence is that of Mr. Calouf, who says that's all true, but it's incredibly unlikely to succeed. And there's your point, which you made yesterday, that is going ahead anyway. So in practice, what's the problem? But we do want to bottom it out. We don't want further submissions about it at this stage, but we do want to bottom out precisely where the evidence stands on that, whether the crude summary I've just given you is accurate. And if there's any more you want to say about the relevance of that evidence, we'd like to hear from you on that. Not now, but we thought we'd alert you to it now so that you could deal with it when you make your other submissions later.
There are other appeals, and in fairness, the company has appeals as well, which are dealt with in Canada, which I should update you on as part of the overall picture.
Well, very well. Let's not spend any more time. We just to alert you to the fact that that is something that needs to be dealt with. Any other aspect of it I should be mentioning?
No, I mean, from my point of view, it was really whether there's anything further than Calafilo on, for the reasons he gives, an appeal is impossible or unlikely. A successful appeal is impossible or unlikely.
Yes,
I'll take whether I've missed some further material.
I don't think you have.
And if we're dealing in certainties or uncertainties, if that is an uncertainty over whether the novel system will survive at all, which I understand to be the relief which is sought, because it seeks an annulment of the whole priority access procedure, and the novel system was made in priority access number 7.
Number 7.
That's my understanding of it at the moment.
Your lordship's thinking.
And that was, I wanted to make sure that you knew that was in my mind,
I'm
and
grateful.
you had made sure that I was made aware of all the material that's relevant to that.
Thank you.
Yes, Mr. Toledano.
Thank you, Mother. Yesterday I was making some points about the regulation itself, and I'd made points about the recitals in particular. I wanted to just make a couple of very short points about the provisions of the article, Article 34 itself, if it's helpful to have it open, it's in bundle F of the authorities bundle at tab 52, at page 1755.
Sorry, just give me one moment.
Tab 52 of bundle F, page 1755. I don't have anything to add at this point on, in relation to Article 34, paragraph 1. I think you've already been shown paragraph 2, which is important. It's contained in both Articles 33 and 34 and makes it clear that the stay is not a once and for all stay. So the court retains the jurisdiction to continue the English action if one of the conditions set out in paragraph 2 is satisfied. And as you can see, those are widely drawn, particularly the last one about the administration of justice. And there's nothing equivalent to paragraph 2 in Articles 29 and 30, which concern, as you know, the relations between EU member states. And that is an important feature of Article 34 that shouldn't be overlooked. If this court were to dismiss the appeal on Article 34, there is nothing to prevent the claimants returning to the judge to seek to lift the Article 34 stay if circumstances in Brazil change in a way that no longer makes the stay necessary for the proper administration of justice. So that's paragraph 2. Paragraph 3 of Article 34 provides that the member state court may dismiss the action if the action in the third state has resulted in a judgment capable of recognition or enforcement. And there's a similar provision in Article 33. The difference is that under Article 33(3), the member state court is obliged to dismiss its action, whereas in Article 34(3), it has a discretion to do so. Now, in my submission, the explanation for that difference is that in the case of Article 33, the regulation is dealing with the same cause of action, same parties. And that means that the judgment in the third state court will therefore create a cause of action estoppel, and there'd be no possible point in continuing the proceedings, hence why Article 33(3) says shall dismiss the proceedings. The same is not necessarily true in the case of Article 34. And the important point about Article 34 is that, as per Recital 23, it's a flexible mechanism that allows the court to stay its proceedings even though the action in the third state may involve different causes of action and different parties and may not, as a result, produce a judgment with binding res judicata effect at the end of the day. And it may nevertheless be a judgment that it's appropriate to wait for, and we submit that is expressed from the terms of Article 34. The only other thing I wanted to draw the court's attention to is at page 1756, very briefly. This is in the next chapter concerning recognition and enforcement, and you can see, I'm sure you're familiar with this already anyway, but Articles 36(1) and 39(1) provide that judgments given in member states are recognisable and enforceable in other member states without special procedures or declarations. And those provisions obviously don't apply to judgments of third states, so national rules apply, which will obviously vary across the EU member states. And therefore, unlike under Articles 29 and 30, it cannot be assumed that the third state judgment is capable of recognition or enforcement. And that's why, as we've seen, both Articles 33(1)(a) and 34(1)(b) ask the question whether it's expected that the third state court will give a judgment capable of recognition and enforcement. It's not, in my submission, a question that's concerned with how likely it is in the particular case that a judgment will be given or when. It's only a question about whether such judgment will be capable of recognition or enforcement. The other point that I wanted to just draw your attention to is in the context of considering what factors come into play under 34(1)(c and under discretion. And I know you've seen recital 24, which gives you some input in relation to what factors the court would take into account. But there's also one passage I just wanted to draw your attention to from the judgment of Lord Clark in the Supreme Court in a case called the Alexandros T. That's in Authorities Bundle, Volume F, at tab 47, at page 1477. Now, just so that you know, this was actually an Article 30 case. In fact, then it was Article 28, but now it's Article 30. But the principles that apply are equally applicable to Article 34. And indeed, Mr. Justice Fancourt, in the case you've already been shown, the Privet Bank case, the Privet Bank against Kolomoisky case, he quoted the bit I'm going to show you in the context of Article 34 at paragraph 160 of his judgment. And so if you'd be kind enough just to look, I only want to show you one paragraph, really. It's at 1508. And if you look at under the heading discretion, at the bottom of the page, in paragraph 91, Lord Clark says that the court has come to the clear conclusion that a stay should not be granted, and that's going over the page to the top of the next page. And then in paragraph 92, what he does is he refers to Advocate General Lentz's opinion in the Owens Bank against Bracco case. And he had identified a number of factors which he thought were relevant to the exercise of discretion, and they can be briefly summarised in this way, according to Lord Clark. Circumstances of each case are of particular importance. The aim of Article 28 is to avoid parallel proceedings and conflicting decisions. In case of doubt, it would be appropriate to grant a stay. Indeed, he appears to have approved the proposition there's a strong presumption in favour of a stay. Identified three particular factors as being of importance. One, the extent of relatedness between the actions, the risk of mutually irreconcilable decisions. Two, the stage reached in each set of proceedings. Three, the proximity of the courts to the subject matter of the case. And then an important final sentence. In conclusion, the Advocate General said at paragraph 79 that it goes without saying that in the exercise of the discretion, regard may be had to the question of which court is in the best position to decide a given question. And we do say that's an important test, which does have some resonance on the facts of the case before your lordships and my lady. You'll notice that the three factors that are identified, factors 2 and 3, overlap with the first two factors mentioned in recital 24. Factor 1 is a little different and focuses on the extent of relatedness and the risk of irreconcilability. So that's all I wanted to say about that. Can I just deal briefly now with the question that my Lord Justice Popplewell posed yesterday about the point in time at which the court must be satisfied in relation to the Article 34 test. My answer to that is essentially the same as that given by Mr. Gibson in relation to abuse, with one possible caveat. In other words, the relevant question is whether the judge reached the right decision on the threshold points and exercised his discretion properly, as at the date that he did so. This court would only be concerned with subsequent developments if it were to conclude that the judge went wrong and the court has to re-exercise. The one caveat is that it is arguable that the related action in the third state must be pending as at the date when the action in the member state is initiated. So to that extent, you wouldn't be looking for that question as at the date that the judge is exercising the power. You'd actually be looking at an earlier point in time. You'd have to test whether at the point of initiation in England there was a pending related action in the third state.
Yes, but the evidence you would be looking at the evidence about that question. just as you're looking at the evidence for any other question that arises under Article 34, in the way you've been suggesting. Primarily, at the time it was before the judge, but if his decision is vitiated by errors of principle, and we are looking at it again, then as the evidence is before us.
Yes, my lord, yes, exactly. And anyway, nothing turns on the pending point because it's common ground that the 155 was pending at the time that the English action was commenced. So that's all I wanted to say about the regulation specifically. And then I turn straight away to Article 34(1)(b). And you'll recall that my learned friend took 2 points in relation to Article 34(1)(b). And the first one I'll turn to is whether the claimants are correct to reformulate, that's the way we would put it, reformulate the article into 2 separate questions. Is a judgment expected? And if so, will it be capable of recognition? And I can take this relatively shortly because the court has helpfully already identified many of the key points when discussing this with my learned friend. And I've already mentioned some of our points anyway when looking at the regulation. That there are, in my submission, 6 points that demonstrate that there is only one question under 34(1)(b) which concerns whether a judgment will be recognised. First, my learned friend's main argument concerned the language and syntax. And in my submission, those matters should not be given too much weight in an EU regulation of this sort. It's well known, indeed, as my Lord Justice Popplewell indicated, that the CJEU takes a broadly purposive approach to construction, having regard to recitals and context. Certainly it would not be correct to adopt too literal an interpretation. And what is more, on the language and syntax, in my respectful submission, my learned friend overstates the point. The language and syntax used can readily accommodate an interpretation that only requires the answer to one question about whether a judgment will be capable of recognition. And I would add this about the language as well, that my learned friend said the standard he contended for was a real prospect of a judgment, but that's not actually stated in the article itself, and in a sense requires something to be read into the article, which is hardly consistent with his case about the language supporting his construction. So that's the first point. The second point is that the purpose of the provision is to cater for the fact that there is no automatic recognition of judgments of a third state, unlike judgments from member states. Hence why there is no equivalent of this provision in Articles 29 and 30. And it's worth noting that Articles 29 and 30 also do not contain a separate requirement for the court to assess the likelihood of a judgment being given in another member state. That just isn't found at all in 29 and 30.
Now, 1 second. Your point is that if it meant what Mr. Choi says it meant, that would effectively half the question would still fall to be asked. Yeah.
My Lord, yes, exactly so. So that's the second point. The third point is the recitals. Both 23 and 24 strongly support our construction and not that of my learned friend, in particular because the expectation of a judgment within a reasonable time is only addressed in recital 24, not recital 23, and is therefore only to be addressed under 34(1)(c and not 34(1)(b). The fourth point is that it's inherently unlikely that the threshold condition was intended to require an analysis of whether a judgment was expected, since that would follow in the usual course from the fact that proceedings were pending, which I think was a point that my Lord, the Vice President, put to my learned friend in argument. Fifth, the threshold condition should not be given a construction that would make them more onerous and restrictive in circumstances where the whole aim was to produce a flexible mechanism, as we've seen. And then sixth and finally is the Travo, and we're grateful to my Lord, Lord Justice Underhill for raising the matter, and indeed to his judicial assistant. We have buried into the documents, the relevant Travo documents, and we have provided to the court and to my learned friend a short note and exhibits in a bundle. It's called the Respondent's Additional Material Bundle. I think it should be a white one Essex Court bundle.
It's enormous.
It's enormous. My lady is right.
The notes may be short, but I think the
but
bundle comes.
I was about to say exactly that it's actually a short note at tab 1, and it's actually an even shorter point than the note suggests, and therefore, although we have provided the relevant accompanying documentation, I don't think this is going to be taken
There are too many trees in the world, I've always thought.
Well, I apologise for that. The short point is that the draft text of the article contained both a requirement relating to the expectation of a judgment within a reasonable time and a requirement relating to a judgment capable of recognition. And when I say the draft text of the article, it was actually the draft of what became Article 34, not 33, not 34, but that doesn't matter because they both contain the same provision in relation to this 1B point. The draft text was then amended, and such that the rendering of a judgment within a reasonable time came out of 1B and instead went into what became Recital 24, as we've seen. So that's the short point, and you'll see that if you look at the note. I can take you through the note in more detail, but really that is the point that comes out of it. If you look briefly, for example, at paragraph 9 of the note, you can see the original proposal is referred to, and in line 3 can exceptionally stay proceedings, and it is expected to decide within a reasonable time, and the decision will be capable of recognition and enforcement. So the two were put together in paragraph 9 of the original proposal, and you can see in the text at the top of page 3 of the note, in 1B, that the original draft said it may be expected that the court in the third state will, within a reasonable time, render a judgment that will be capable of recognition and, where applicable, enforcement in that member state. And then that was amended, and if you look over into paragraph 15 of the note on page 4, you can see that that point went into the recital, which we've got set out, which became recital 24, and the new wording of the article, which you can see in paragraph 17, took out the point about rendering a judgment, that it was expected that the court would render a judgment within a reasonable time. So that's the drafting history which comes out of the Travo. And we've also included in the note, as you can see towards the end, authorities that indicate that the court is entitled to have regard to the Travo when interpreting the regulation, which I think was a point that the court raised. Now, in my submission about this is that it would make no sense against this background for the question about whether a judgment was expected and when to be asked twice rather than only once under Article 34(1)(c). And so that's really what we say comes out of looking at the Travo and the drafting history.
But it is only the implications to be drawn to the drafting history. There's no discussion in any paper that is available as to why that change was made.
Indeed so.
Right, okay,
and that's why I don't want to overstate how much weight we place on the Travo. It's just one point. As I say, it was actually the 6th point that I came to. We're not suggesting that in isolation it provides a complete answer to the question that the court has to decide. We're simply putting it before you because it did seem to us, once the court had raised it, that it was relevant and that you should know about it. And we do say that it supports our construction, but I don't want to suggest that I'm putting too much weight on it, because I don't. So that's the points that I wanted to make about that argument. It's important for me to add, though, and this is a little bit more, takes a little bit more time to develop, but it's an important point and comes up under 34(1)(c) as well, that we do have a further argument, which is that we satisfy the test under 34(1)(b), even on my learned friend's formulation, because in my submission, it is expected that the 12th Federal Court will give a judgment, because if no settlement is reached, then that is what will happen. And the court will have to determine any claims and issues arising in the 155 that have not been settled. And as I say, I do want to spend a little bit of time on that, not only because of 34(1)(b), but because of its relevance under 34(1)(c) as well. Now, the claimants make their argument.
Just before you embark on that,
of course,
there's a dispute between Professor Rosa and Professor Didier about whether there'll ever be a 155 judgment. Are you going to ask us to resolve that issue, or do you simply say, at least for the purposes of this argument, you satisfy the real prospect test? Because if we can't reject Professor Didier's evidence on it, that means there must be a real prospect of the judgment being given.
Well, I think my answer is both.
All right.
Which unfortunately makes life a bit harder in a sense, but I think my answer is both.
Maybe it's too early before you've developed your point, but is there a third possibility, which I thought is what you were saying, that even if you ask, is there a real prospect or was it expected, that isn't meant to be some sort of crystal ball gazing. It's meant to be more whether there's a procedural prospect, whether that's the next step in the... Is that part of your submission or not?
Well, my lord, yes, indeed, and that goes back to not giving the threshold conditions a restrictive or onerous interpretation.
It may come back, it may almost be much the same as your main argument, actually, but forget it. Keep going.
So the claimants make their argument on the back, as we know, of the evidence of Professor Rosa and what he says about the effect of clauses 99 and 103 of the GTAC. And essentially he says, well, they provide for a contractual arbitration mechanism, which means that the court won't try the 155 or issues in the 155, but would arbitrate in respect of issues not agreed in the negotiations. And he says, well, that won't include the issue of the joint and several liability of the defendants in the 155 because of the way that this whole process is working. Now, in my submission, the judge correctly concluded that there's nothing in this point. And I do want to just briefly invite your attention back to what the judge said at paragraph, starting at paragraph 176 of his judgment, which is in Bundle A, tab 9, at page 261. So it's at the bottom of page 261, and he referred to the fact that the federal prosecutor had explicitly asserted in the 155 that BHP Brazil as an indirect polluter should be jointly liable. Brazil has denied and continues to deny this. The matter was dealt with in exchange between Mr. Hollander and myself on the final day of the hearing. And then the judge said he might say that I want BHP to put its hands up and say whatever funds are required, they'll be jointly liable regardless of Vale's contribution. And Mr. Hollander said he could do that. And then at 177, of course, one may speculate the issue may not be pursued by the federal prosecutor after all, but as matters presently stand, this is a question which, unless settled, will be the subject matter of a judgment of the Brazilian court. And then if you look on a couple of pages to paragraph 185, where the judge said the claimant sought to advance the case suggesting it was all but inevitable there would be no judgment arising from the outstanding disputes. The reasoning behind this approach was, I have to say, elusive. And then in 186, he says he was invited to treat...
What evidence is he referring to here?
Well, this is the evidence, I think, from the experts, which I'm going to come to, from Professor Rose and Professor Didier. But what he's saying, I think, here is that it's you know, that the idea that it was all but inevitable was the argument was elusive. And then he goes into the arbitrator point at 186, and he says he found that unhelpful. And he says, in the event that agreement were not reached on any aspect, the judge would be acting as a judge and would be expected to deliver a judgment on any issue.
How does this grapple with what Professor Rosa says?
Well, I think this is just showing you how the judge approached it, but I agree. One does need to grapple with that, and I'm going to come to that straight away. And then you can see 187, just very briefly, just to finish the point, on the final day of the hearing, Mr. Hollander conceded that even on the evidence of his own expert, the possibility that Judge Mario would adjudicate on matters not agreed was not fanciful. This was an important and realistic concession. The prospect of irreconcilable judgments relates to the risk and not a likelihood that there will arise the chance of settlement in most civil cases, and so So that's how the judge dealt with it. And then, can I just, first of all, before I go to Professor Rosa, can I just go back to, I know you've seen these, but to clauses 99 and 103 of the GTAC.
Just while we're there, sorry, Mr. Tolan, do you agree that 188 is wrong as a matter of Brazilian law? Because a ratification wouldn't be a determination on the merits.
Well,
This was the judge's idea.
This was the judge's own point, wasn't it?
This was the judge's own point, and to be fair, I think, as you know, we were not really pushing this point below.
No.
And
you're not maintaining it here, are you?
I'm not pushing it here either.
No.
So,
Thank you.
The short answer to my lady's question is we don't run that point. What I wanted to do briefly was just go back to 99 and 103 of the GTAC, which is in volume G, tab 19, at page 1024. I know you've seen this already, but so at the foot of page 1024, you have 99 of the GTAC. What we're really interested in is the sole paragraph at the top of the next page. If the parties reach a partial agreement or are unable to succeed in the renegotiation, the matters in relation to which there is no convergence may be submitted to the 12th Federal Court for processing in the records of the public civil action. And that, of course, has to be read with 103. So if we could look over the page to 103, paragraph 1, which is at the top of the next page. On the terms of the sole paragraph of 99, if the Federal Public Prosecutor Office understands that any of the claims made in the CPA that has not been addressed in the renegotiation process may be submitted to the 12th Federal Court so that the ACP may proceed with respect to the items on which no consensus was achieved in the renegotiation process. Now, the wording there is important because what that's telling you is that if there's a claim that hasn't been addressed in the renegotiation process, then that can be referred to the court, and the CPA itself will proceed or may proceed with respect to that item. So if you have a claim such as BHP Brazil is jointly and severally liable as an indirect polluter, if that claim is not settled in the settlement negotiations and is not dropped or withdrawn by the federal prosecutor, then it can be submitted to the 12th Federal Court. The CPA itself will proceed in that regard, and then there would have to be a judgment on it. So we say it's really clear on the wording of these provisions, particularly paragraph 1 of 103, that there is a realistic prospect, if the settlement negotiations don't work, that there will be a judgment that will actually be in the CPA, because the CPA will proceed, and will relate to any claims not resolved. And then, so that's what the provisions say, and then if I could invite your attention to Rosa, Professor Rosa, at paragraph 460, that's at page, that's in tab 34 at page 2178.
Bundle K.
I'm sorry, of course, yes, bundle K. Sorry, I'm using a laptop, so I must remember to give the bundle number. Now, in that paragraph 460, at tab 34, he himself acknowledges that in the scenario being considered, the CPA will continue. So you see that in line 4 of his paragraph 460. And he's saying that that's what will happen if a TACF is not agreed on all issues. And then you can see also at line 6 that he says in that process, the MPF may also refer to the 12th Federal Court any other claims which were not dealt with in the renegotiation process. So he's not really disagreeing with the proposition that I just put to the court based on the terms of 99 sole paragraph and paragraph 1 of 103.
It's the next sentence.
Well, he says, as an arbitrator, but in my respectful submission, the judge was right that that distinction is not really helpful. If you're being told that the CPA may proceed, then the CPA is proceeding and the judge is acting as a judge. He says, instead of resuming a process leading towards a full trial, well, that just depends on what is agreed in a settlement or not agreed in a settlement. If, for example, the settlement discussions break down completely, then the whole CPA could resume and there would be a whole full trial. That just depends on what is or is not agreed in the settlement. Now, for your note, and I'm not going to go to it now, but Professor Didier has analysed, as you know, 99 and 103 himself, and the relevant reference for that is Didier 2 at paragraph 280, which is in volume L, tab 37 at page 2432, and we've summarised that in our skeleton at paragraph 145A. I think my learned friend was suggesting that it's only matters discussed in the negotiations and not resolved that could be decided by the court, and that the liability of BHP Brazil was not being discussed in the negotiations. My submission is, if that is what my learned friend was saying, it's clearly not right in the light of paragraph 1 of 103, and indeed in the light of what Professor Rosa says. If a claim, such as whether BHP Brazil is joint and severally liable, is not discussed and not resolved, then unless it's withdrawn, it will be determined by the court as part of the resumption of the CPA. Now, the appellant's other point is to say that the liability issue is highly unlikely to be tried because the prosecutor has already bought into the Renova structure, and the companies won't want a trial of liability either. And that's how he put it in Rosa 1, which is volume K, tab 34, 2179. I think it's just a couple of paragraphs on from where we are, 463, over the page. And what he's dealing with here is, he says, it's almost impossible that there will ever now be a trial of liability. So he's not saying anything about the other issues that are still live in the 155. As to a liability trial, he accepts it's theoretically possible, and you can see that from lines 2 and 3. It's possible in theory there could be a trial on liability, and then he repeats it in line 6. It's therefore possible in theory. And so he's not suggesting, if you like, in principle, that there couldn't be. What he's really saying is that it's unlikely. And then if you go to 464, he explains why he thinks it's unlikely. And he says, well, it makes no sense for any of the parties for there to be a trial of liability. Now, as to what he says in 464, of course, we agree that the parties have agreed the full redress principle already, and we agree that Renova's been ratified and so on. But his opinion that there will therefore be no trial of liability, it is, in my submission, pure speculation. The prosecutor seeks joint and several liability in the 155 as is common ground. That was not settled in the GTAC. The lack of joint and several liability was one of the specific complaints the prosecutor made in the 155 about the earlier TTAC. It was one of the very things that the prosecutor said was inadequate about the TTAC, that it didn't provide and conclude that there was joint and several liability. And in my submission, there's no reason to believe at this stage that the MPF will give up this point. Certainly no basis for saying that that is likely. And as you know, the liability issue is only one of the issues that's not yet been agreed and may yet be tried. There's also the generic causation and damages issues, which certainly on our case arise in the 155.
Well, sorry, I've probably missed that. In what sense do they arise in the 155?
Well, and I'm coming to this a bit later.
Coming to it later.
Just by way of brief summary, I think as you've heard, in relation to the in-kind relief that the 155 is concerned with in part, our case is that when deciding on those questions, the court will have to make generic causation and damages conclusions. and it would be impossible not to when deciding whether to order a particular relief, such as a clean-up or something of that kind, and that those issues, unless they're settled, unless all of that is settled in the settlement discussions, those issues could also or would also be determined by the
You're coming
court.
back to that later.
Yes. So that's all I wanted to say about could there be a trial or will there be a trial.
Sorry, just before you leave that, I mean, Dr. Jano also says something about this, doesn't he? He's a former public prosecutor. I think he says, this may be related to new CPA, but the logic's the same, that it's entirely implausible that a public prosecutor would pursue it, because it takes a long time and it's very expensive, and there's got to be some sensible utility to it. And the 155 CPA hasn't gotten any further than a new CPA in terms of the court proceedings.
Well, what I'd say about that is I think your Lordship is right that was said in the context of a new CPA, and I'm going to come to a new CPA. I don't agree that the 155 hasn't got any further than a new CPA. I don't agree with that at all. The 155, it's right as we know that it's been stayed for settlement discussions to take place, but the 155, as you know, it's not just it's stayed and then nothing happens that involves the court, for example. It's been stayed. There's been this detailed process of negotiations that has had some judicial oversight. There's been the priority access, as we know, and everything else that's been going on that has involved the court that is very closely related to the CPA. So the 155, in a sense, has been stayed, and therefore your Lordship's point is right. But in another sense, it wouldn't be right to think of that as a new CPA. Far from it. The judge dealing with the 155, Judge Mario, is absolutely immersed in all of these issues, and a lot of progress has been made.
But the logic would apply at least to the question of whether it will be pursued to establish the liability of the companies. That hasn't been touched on.
Well, that hasn't been touched on, but as I say, the stronger evidence than what Jano says is that the prosecutor himself in the 155 has sought a finding of joint and several liability and has specifically complained that the TTAC was inadequate by not having that as one of its conclusions. And there's just no reason on the material before the court to think that all of that is just going to be thrown away by the prosecutor absent a settlement that the prosecutor is prepared to buy into. Of course, I will come to the new CPA issues when I deal with the consolidation argument that we make. So that's all I wanted to say about the first point that arises under 34.1b. Then there's the second point that arises under 34.1b, which is recognition and enforcement, and whether a judgment in the 155 is expected to be capable of recognition or enforcement. Now, the position in my respectful submission is straightforward. A judgment of the 12th Federal Court is, in principle, recognisable in England. Now, the claimants contend that it doesn't satisfy the requirement because it wouldn't bind the parties on whose behalf the CPA has been brought if the result is adverse to their interests, and would in that situation therefore not be final and conclusive. The judge, as you know, held that that particular feature of a CPA did not prevent 34.1b from being satisfied. That was in his judgment at paragraph 203. And the essential point that we make is that the expectation in 34.1b is not of a judgment that will in fact and in all eventualities be recognised, but rather of a judgment capable of recognition. And a CPA judgment is capable of recognition because it will be final and conclusive if it is favourable to the affected persons. And we do respectfully adopt the point revealed by the example my Lord Justice Popplewell gave of the 36 out of 37 different ways that would produce a recognisable judgment and one that does not. It would make no sense if that scenario were to fail at the threshold stage. And here too we do also pray and aid the intention, which was to produce a flexible mechanism which suggests the threshold conditions are not to be interpreted in a restrictive way, which would denude Article 34 of its scope and purpose. Now, we do accept, and this may be helpful just for the court to be aware of this, and you may have picked it up from our skeleton, that the position would be different if the judgment of the third state court was one where, regardless of who wins and who loses, the judgment could never be final and conclusive. And there is an example of a judgment like that in the authorities. It's a House of Lords case called Nouvion against Freeman. It's in, well, I'm not going to go to it, but for the note, it's in volume D of the authorities bundle at tab 37. Now that concerned a remate judgment in a Spanish court, and that could be disregarded by whichever party lost, and a new action commenced in its place, and it could therefore never, under any circumstances, be set up as a res judicata. And that we draw to the court's attention just by way of comparison. That is not the case before this court, and we say we're different, and therefore we come within the article. Now, of course, we accept that the way that a CPA judgment works is relevant in the context of the administration of justice and discretion, but it doesn't pose a problem so far as 34.1b is concerned. So that's 34.1b, and then I was going to move on, if I may, to 34.1c and the exercise of discretion. And we support, as you know, the judge's conclusions, which are set out really in paragraphs 204 to 234 of his judgment.
Sorry, just before you do that, are there any categories of claimant, either the 58 or within the 58, for whom the judgment wouldn't be res judicata, even if it finds liability of the defendants? I had thought that it was common ground that was the effect, at least so far as the large companies and I think the utilities.
Does your lordship mean that the question of whether they could benefit from a generic sentence? Because I think if that is what your lordship is asking about, then your lordship is right. The 58 cannot benefit from a generic sentence of liability rendered in the 155.
So if you just take them, I don't know whether this is a 34.1b point or a 34.1c point, or both. But if one's doing a wait and see, just look at them individually. You're doing a wait and see stay to see what it says. It won't have anything to say which is binding on them, whatever happens.
Well,
either way. Is that right?
First of all, I accept those kind of considerations are relevant for 34.1c. I don't accept that that's a 34.1b point, because the only question in 34.1b is the judgment capable of recognition? And it is capable of recognition.
Not for them.
Well, it's capable. It's not a question that's being asked about, but bearing in mind that Article 34 can be dealing with different parties in the two actions. It's not a question that's you're not being asked, will it be? And I think Mariana made it clear, he's not suggesting it has to be a judgment with res judicata effect in relation to the parties to the action in the member state. So it's just a question in principle, is it a judgment that's capable of recognition? And
Well,
it is.
that's rather surprising, isn't it? If I have a claim, which I'm entitled to bring as of right here, and which, if I were bringing it on my own, could not be stayed under Article 34, you're saying, well, it falls to be stayed under Article 34 because there are some other claimants in the proceedings whose own claims can be stayed.
No, I wasn't suggesting that, my lord. Even if you brought your claim on your own, say you were one of the big companies, you brought your claim on your own, we could still apply to have that claim on its own stayed under Article 34 because of the 155. And the reason for that is that Article 34 and indeed Article 33 are concerned with avoiding the risk of irreconcilable judgments. And that is an aim of the administration of justice per se. And you want in order to avoid that risk if you have related actions, and related we know means effectively the test in 34.1a, i.e. that the actions are closely connected, that it's expedient to hear and determine them together to avoid the risk of irreconcilable judgments. If you have that, then you can stay, even if the judgment that will come out will not directly provide relief one way or the other, or determine the claim one way or the other of the person bringing the claim in England, because it may still be
the corollary of the width of the Sario relatedness.
It is.
I understand the point.
That's exactly right. That's exactly right. And indeed, at one point, my learned friend was saying, well, no, that Sario test can't apply to Article 34. And I think he now accepts that it does. And that's why he's conceded that 34.1a is actually satisfied. But my lord is right that the Sario test is very wide. You'll recall that said that it's a broad brush approach. You don't look at whether it's a precise overlap of an issue that's essential to the cause of action or anything of that kind. And that test is the applicable test. And of course, I accept that when it comes to the discretion of the administration of justice, you do have to then ask yourself, well, given those circumstances, is it still necessary to stay in order to await the outcome, to avoid the risk of irreconcilable judgments? And there have to be obviously reasons why you would wait. And we say that there are in the facts of this case.
Even for the 58, because for these purposes, irreconcilability just means having something to say on issues which overlap.
Indeed. Indeed, and of course we do also say that there's more in it for the 58 than just that. We do say that they will benefit from all of the in-kind relief, as your lordship knows, which is all subject to the 155 as well, and is being discussed in the settlement discussions. We also say. Sorry,
you've lost me on how that's in other words to this question.
Well, in other words, I think what I'm going to is what would, and I'm coming to this in my submission, but what would be the purpose of a wait-and-see stay for those claimants? And one purpose is, well, you avoid the risk of irreconcilable judgments, and that in and of itself is the function of the stay and the purpose of the stay because of the administration of justice. Another is that there will be advantages to the 58 of waiting, because if there's a settlement or a judgment in their favour, in the 155, there will be in-kind reliefs that they can benefit from and will benefit from significantly. For the municipalities, there will be decisions or a settlement relating to their extraordinary expenses, which is a claim that they bring there and a claim that they bring here. And all of that is worth waiting for, even for them. And I'll come to this. In a sense, I'm moving ahead of myself to what is the purpose of a wait-and-see stay, but I'll come back to that. What I was moving on to then was 34.1c in discretion, and I was saying that we really support the judge at 204 to 234. We say he was plainly entitled to come to those conclusions and that this court should not interfere with them. And I want to really make my submissions and address the points my learned friend has made following the structure in our skeleton. And you'll have seen there are 6 topics we cover in the skeleton and 6 topics I'm going to cover now. First is the extent of the relatedness of the action.
Might be useful to have the skeleton open for those 6 points. Remind me which the passage is.
I think it starts at page 181 of our skeleton, which is paragraph 158. That's the bundle reference, page 181.
Thank you.
And you can see that the first heading is the extent of relatedness, and that goes together with the degree of the risk of irreconcilable decisions. The second heading is the connections between the facts and the parties and Brazil. The third is the point of a wait-and-see stay. Fourth is consolidation.
Yeah.
Fifth is the stage the Brazil proceedings have reached and the expected timeline to resolution. And sixth and finally and briefly will be the priority axes.
Yes, I'm so sorry. I may have misunderstood you. I thought you were actually, as it were, making your submissions by reference to the skeleton.
Oh, well, to some extent I will be, but so it's helpful for your lordship to know where I am anyway. So I was going to turn then to the first point, which is the extent of relatedness and the degree of risk of irreconcilable decisions. And you'll recall that's the first factor identified by the Advocate General in the Owens Bank against Bracco case that I showed you in Lord Clark's speech. It's undoubtedly an important factor. And the judge concluded, as you know, that the English action and the 155 CPA are very closely related. And I'm going to spend most of my time dealing with overlapping issues. But just before I do that, very briefly, on overlapping claims, which is another way of testing the point, we do submit that there is an overlap of claims between the two actions in the sense that the generic sentence sought in the 155 will give impacted persons other than the 58 the right to obtain the same relief as the relief being sought by the claimants in England. So far as concerns the 58, we acknowledge that their claims for monetary indemnification are not wholly replicated in the 155, but as I've already said, that there are heads of relief in the 155 which directly impact upon their monetary claims in England. And so we do say there is an overlap even for them. What I wanted to address, as I say, most importantly, are the overlapping issues. And that's where my learned friend focused his submissions. Now, the judge found there were many issues of liability and causation and damage which arise in both actions, and as a result of which there was a real risk of irreconcilable judgments. And what I want to do is to start with overlapping liability issues, and really what we're talking about are the indirect polluter allegations, which are made both in the 155 and in the MPOC, the particulars of claim in England. Now, as the court has heard, in the 155, it is an issue whether BHP Brazil should be jointly held to be jointly and severally liable as an indirect polluter by virtue of its alleged control of Samarco. And the court has also seen that in the particulars of claim in England, the claimants plead that control by the defendants of Samarco for the purposes of indirect polluter liability is through BHP Brazil. Now, and that's the headline point, and I'll come to the detail. So we submit that the issue of whether BHP Brazil has a sufficient degree of control over the Samarco joint venture for the purposes of indirect polluter liability is an issue that arises in both cases. And we submit further that where you have an overlap of that kind on an important issue, it must be desirable to hear and determine the two actions together to avoid the risk of inconsistency. My own friend accepted in his submissions, this was page 174 of day 2, lines 4 to 9, that he said it was perfectly true that the issue of strict liability as an indirect polluter as a generic issue is common to both sets of proceedings. Now, of course, he went on to minimise the overlap, and I'll respond to that in a moment, but it's important to recall that he accepted that as a generic issue, that issue, strict liability as an indirect polluter, is common to both sets of proceedings.
That doesn't of itself necessarily involve any overlap. I mean, you need to look at what the detail is.
The detail matter, I entirely accept that. It is all in the detail.
But I didn't quite understand why you say it's important to keep that in mind.
Well, it's a starting point. Maybe that would be a better way of putting it. Now, there was also quite a lot of common ground, really, about this in the court below and on the evidence. There is Professor Rose's first report, which maybe I'll go to briefly. It's in Bundle K at tab 35 at page 2144. And you'll see he sets out in paragraph 375 four matters, and it's the first two that we're really concerned with. What are the requirements of environmental law to establish an indirect polluter? And did BHP Brazil control Samarco? And then in 376, he says, I agree with Mr. Vivan that in principle, if there were to be a trial in the 155, these matters might be an issue, and that there could be some overlap with issues arising in the trial of liability of PLC and Limited in the English proceedings. Then he says, in practice, the extent of the overlap is very small in comparison with the different issues which might arise in the English proceedings. So he does accept that in principle there'd be overlapping issues on those 2 points about the requirements of Brazilian environmental law and about whether BHP Brazil controlled Samarco. And then what he does is he seeks to minimise that. And if you look...
the difficulty I have with this is, of course, he's qualified to identify what arises in Brazil as a matter of Brazilian law and indeed what Brazilian law says. But what the nature of the allegations are in the English action is for us. And I absolutely understand your point on para 275 through BHP Brazil. Mr. Chu Choi's answer is that when you look at the pleading carefully, that doesn't mean that it's alleging that BHP England and Australia, these defendants, can only be liable through their control of BHP Brazil if BHP Brazil would, under Brazilian law, be liable as a controller of Samarco. That expression through, when you look at the rest of the pleading, says we're simply relying on the legal entitlement under the joint venture agreement to appoint the directors of Samarco, and that was a power which it was in fact exercised by the parent companies directly, and therefore it was through BHP Brazil's rights to appoint the directors that the control was in fact exercised by BHP England and Australia. And that's all a matter of analysis of the English pleading. He's either right or wrong about that. If he's right, there doesn't seem to be any overlap because it isn't a necessary stepping stone in the English proceedings to reverse something which involves BHP Brazil controlling Samarco. If he's wrong about that, then he's wrong about that, and there's the overlap.
Well, let me
isn't that all a question of analysing the English?
I don't think it's
the English claim.
Well, I think my lawyer is obviously absolutely right that is a critical part of it. I think it is also important to be aware of what the pleadings in the 155 say as well. And one of the reasons for that is that in England we don't have a defence, obviously. Right. In the 155 we do, and there's therefore a bit more of an indication through the pleadings in the 155 of what the defence in England might look like. And that is a relevant point, and I'll explain why. But I entirely accept what your lordship is saying. That is the key point. That was the point that my learned friend essentially put all his focus on. And let me address that straight away. And I'll takes a little bit of time to develop this, but it is an important point, and we do have an answer to it. So on this point about control and about the argument that your lordship has just put to me. Now, in my respectful submission, in the particular claim in England, there are essentially really 2 layers to the argument. The first layer must be whether BHP Brazil had a sufficient degree of control over the Samarco joint venture for the purposes of the indirect polluter issue. Because what is being said is that through the powers that BHP Brazil had, which were exercised effectively or controlled, or the strings were pulled by BHP PLC and Limited, but through the powers that the BHP Brazil had, it was able to exercise control, or BHP was able to exercise control over the joint venture. So there is an issue about, was it possible for BHP Brazil to exercise control over the joint venture? That must be the first layer. There is then a second layer argument, which is whether, as a matter of fact, PLC exercised whatever control BHP Brazil had over the joint venture. So we submit that the first layer is about how the joint venture was operated, and it will involve consideration of the extent to which it exercised independence from its 50-50 shareholders. The second layer is internal to BHP. It's about whether BHP Brazil operated as an independent subsidiary or whether it was in fact PLC which controlled and called the shots. Now, we accept the second layer doesn't arise in Brazil, but the first layer, whether BHP Brazil had the relevant powers and was able in a position to exercise control over what was a 50-50 joint venture with Vale, that arises in both sets of proceedings.
Well, Mr. Chuchoy says not, because he says in the English proceedings, the only element of the relationship between BHP Brazil and Samarco, upon which we are relying in England, is that there was a contractual right under the joint venture agreement to appoint directors. Apart from that, it's all fact. It is the control was in fact exercised by these English defendants through the individual people and by putting the directors in there and so on.
Sorry, forgive me.
But that doesn't involve looking at all aspects of BHP's ability to control Samarco. It looks at one item, which I suspect is not capable of dispute, as to what the powers are in the joint venture agreement.
But my learned friend can't stop at that point. He's got to say that there's control over Samarco. And what he's saying is that control over Samarco was constituted by being able to put directors onto the board of Samarco, who presumably were then able to, on their case, to direct what Samarco did and to control it. Otherwise, simply saying that directors were appointed doesn't get you anywhere. You have to go further. You have to say the directors were appointed, they were then in a position to control the joint venture, and it was PLC that was whispering in their ear and telling them what to do and what not to do. Hence what I called the second layer issue, i.e. who was calling the shots within BHP PLC, which we accept is only an issue in England. But on the first layer issue, it can't be enough for him to simply say there's a power to appoint directors. That sat with BHP Brazil, but it was exercised effectively by PLC, and that's the end of it. That doesn't tell you control over the joint venture.
Why not?
Well, because, and this is why I go back to the importance of the defence of BHP Brazil in the 155, their defence, and I wanted to show you a bit more detail because you only saw a little bit of the defence, but their defence is that this joint venture was specifically set up to be independent of its shareholders, to have independence built into it. It was a 50-50 joint venture. Each of the two 50-50 shareholders, Vale and BHP Brazil, were entitled to appoint 2 directors. It was 4 directors and then alternate directors. And so there's a real argument that's on the table in Brazil and very, very likely will be on the table in England as to whether BHP Brazil or any other BHP company can exercise control for the relevant environmental law purposes, so that's standard, over the joint venture in circumstances where it's just one of 2 shareholders of a joint venture that's been set up to have an independent management and governance.
To which Mr. Chuchoy would say that doesn't meet the allegations we're making in England. We couldn't care less whether BHP Brazil would, under Brazilian law, be an indirect polluter because of the structure in relation to giving them control. All we're saying is that you, BHP England and BHP Australia, did, as a matter of fact, exercise control by appointing the directors and through a whole lot of other ways. Well, and that little expression through BHP Brazil, which I entirely understand why you latch onto, because it looks at first instance as though they are saying that's the stepping stone. But he says, in fact, that isn't the stepping stone.
Well, but I still struggle with respect to understand how he can stop at that point. What the MPOC seems to be saying is that these powers were exercised, which enabled BHP to put its directors onto the board. And then what's being said is that those directors were told what to do and what to say and were the appointees of PLC. And if PLC was therefore telling them what to do and what steps to take and what steps not to take and so on. That only gets you so far. You then have to demonstrate that that is enough to control Samarco.
So would the whole point depends on it being a 50-50 joint venture with equal numbers of directors. If it had been 51-49 and the directors were shared 3-2, the point would go away.
Well,
Have I got that right?
It depends on the way that the joint venture is set up and the relevant powers that exist and the rights that exist in the shareholders and how the whole thing is set up. And this is all relied on by BHP Brazil. In fact, it's an important point to note that you'll find references in the MPOC by the claimants. They rely on the articles of association of the bylaws, they're called, of the joint venture, and they rely on the shareholders' agreement as well, between the shareholders and the joint venture, and they say that those things, as it were, can be part of their case. But in BHP,
All right, what I put you was a shorthand for all that.
it is, yes. But you'll see in BHP Brazil's defence, they rely on the bylaws and on the shareholders' agreement to say we did not have the power to control the joint venture. That's not how it was set up. It was set up to be independent. We were not able to control it. Now, whether there's a question of fact there. There's also obviously a question of Brazilian law, whether in circumstances where you have this type of joint venture set up, whether that's good enough to come within the indirect polluter liability is no doubt an important question of Brazilian law. And it's another reason why we say you should wait for the 155 to see what the 155, what the judge in the 12th Federal Court has to say about that question. And you'll recall that on the law, all that the law itself says is there can be direct or indirect polluters. That's all that the statute says. Then all we know at the moment is that there's one judgment where one judge, Justice Herman Benjamin, has said that includes ownership stroke control. Now the question of what that means in the context of a 50-50 joint venture like this will require an analysis of the law and also of the facts, of the shareholders' agreement, of the bylaws and so on. Those documents about the joint venture are pleaded in England, they're pleaded in Brazil. And in Brazil it's being said they do not give us control, and in England it's being said through those powers they do give us control.
Be it assumed that it were common ground that in Brazilian law both the ability to appoint directors and the exercise of that right would not be sufficient in Brazilian law to amount to control for the purposes of indirect liability. The claimants say, we're saying more than that in England. We are saying that actually the control was directly exercised by these defendants in the management of Samarco over those directors.
Well, that's not. But if you look closely at what they're saying in the master particulars of claim, they are saying that, but they're saying that that was done through the appointment of the directors, who were then controlled and told what to do.
What do you mean by through? But it's the telling them what to do that matters. That is the practical exercise of control, which isn't alleged in England to have been what BHP Brazil were doing.
Your point is it's got to be telling them what to do with the right to do so. Is that it?
Well, my point is there's two layers to this. The PLC might have been controlling the directors. You've still got to go on and ask the question whether the directors were able to control the joint venture. The second question is in issue in Brazil. It must also be an issue in England. Otherwise, you don't get anywhere. You would end up with a conclusion that simply says PLC was able to call the shots internally at BHP and direct who should be appointed to the joint venture and what they should do once there. That only gets you so far. And the question then is a question of fact as to whether those directors, at the behest of PLC, were controlling, as a matter of fact, the joint venture. That must be part of the case in England. Otherwise, it's impossible to see how they get to a point where they say there was ownership and control of the direct polluter. The direct
That's at the Samarco level. That's not at the BHP Brazil level. That's at the Samarco level. So it's not, the overlapping issue is not whether BHP Brazil had control over Samarco. It is whether the BHP appointed directors controlled Samarco. That's very different from the way it's been put so far, but is that what you're saying?
Well, I'm not sure there's really a distinction between those two. But BHP Brazil has the right to appoint the directors.
But if that's just a legal right and it does absolutely nothing else
Right, but
can be attributed to it, that's very different from actually appointing the directors pursuant to that right and controlling them as a matter of practice.
It's all about, in the end, who controlled the joint venture. Because the allegation that's made is that the direct polluter, Samarco, was controlled by somebody else, and the somebody else is an indirect polluter.
I understand that.
And the somebody else is being said by the claimants was effectively PLC because it was calling the shots. And what we're saying is that must involve the proposition that it told its subsidiary what to do, and its subsidiary then did it.
No, because it doesn't do it in stages like that. It says the subsidiary had the right to appoint, but we appoint, but the parent appointed, and the parent directly told the Samarco directors what to do. I understand, I think now, your point that what will have to be decided in order to determine whether Samarco was a direct, whether no, I don't. I'm not sure I do. I'm not sure I do understand it because I'm not sure where you get that issue in Brazil now.
Well,
the issue of whether the BHP side appointed directors controlled Samarco is an issue in England, but is that an issue in Brazil?
well, in Brazil, the allegation is that BHP Brazil controlled Samarco, and the response from BHP Brazil is, no, I didn't. Samarco is independent. Now, it is very, very hard to see how there isn't going to be an overlap between that allegation and that defence in England. And this is why I do submit that it's not really adequate to just focus on the MPOC. You do have to have an eye on what are the likely defences to this, bearing in mind what BHP Brazil has said in its defence in the 155, but also bearing in mind that it may well be our case, we haven't pleaded the defence yet, but that the MPOC is wrong and that actually BHP Brazil had its own independence as a subsidiary operating as it did in relation to its actions in Brazil and its ownership of a 50% interest in the joint venture. So I understand exactly why your Lordship is putting these points to me, but the risk, and in the end of the day, what I have to demonstrate is a risk of irreconcilability. My submission that there's more than enough here to suggest a risk of irreconcilability. These are very closely related allegations, and although my learned friend says, well, I can minimise that bit about through BHP Brazil, but what I'm saying is when you look at this and step back and you look at this in totality, it's really not going to be nearly as simple as that. And there's a very real chance of the Brazilian court concluding one way, for example, that BHP Brazil did have sufficient control over the joint venture for the purposes of joint venture liability, of indirect polluter liability, but then the English court concluding no, it didn't.
Yeah, but sorry, you're slipping back into broad brush, whereas before you were being highly analytical, perfectly appropriately, because that's how Mr. Chu Chow was being. And about the highly analytical point is one point, isn't it? Which is whether or not Samarco was controlled by the BHP appointed directors.
Yes.
For the purpose of Brazilian indirect pollution law.
Yes, exactly. In the light of the way that the joint venture...
You say that point is likely to arise, risk of it arising, in England, because it's actually a necessary part of their case, and you will be challenging it. And you're about to show us, I think you ought to show us, that it does arise explicitly in the 155.
Indeed.
Why not show us that now?
So let me go to that then. If we look at the, just very briefly, and you've seen this already, Bundle F, tab 16, at page 754. So this is just so that you know where we are. I mean, this is the particulars of claim in the 155, and it's really just the bit at the bottom of the page, which my learned friend took you to, that they are where it's being alleged that they appear as controlling partners of Samarco, and then there's a reference to the law in the next sentence, the relevant law, which is the same law that's in issue both in Brazil and in England. And then if you look back at BHP's Brazil's defence, that's in volume Q, tab 84.
Volume, which do you say?
Sorry, Q.
Is that a new bundle?
Yeah, I think so.
Yes, it is.
Yes, it is.
It's got the root.
Yes, I'm sorry to interrupt now, but we'll come to it in a second. I've got a bit puzzled because I've now got two bundle Ps, and I thought maybe there's a P1 and a P2.
Now, I think that's probably my fault. I've been told that I've got two bundle Ps because the second one is all single-sided, but the double-sided hasn't been removed from the first one. That's what I've been told. Is that what's happened?
I'm afraid, my lord, I don't actually know the answer to that question. I know that.
Well, let's not spend time on it now, but can you just get an authoritative answer? They don't look as though they have the same things in it. They have. I'll just say this, and then we'll get on to something more interesting. My bundle P runs from 70 to 80. My first bundle, my slimmer bundle, 70 to 82, whereas the fatter bundle runs from 77 to 82, and is indeed only single-sided. Sort it out later. But
of course.
But then Q is also new.
Q is also new.
I mean, but is it just more of the same? Is it a continuation conceptually of P? Yes, I see.
Yes.
Okay, that's fine.
Yeah, it's further documents from the trial bundle, I think, that we.
Yeah, no, now I understand. That's fine.
So if you be kind enough to look at tab 84, this is BHP Brazil's defence. If you go to page 4004. And you can see that at 7.2.1 at the top of the page, the section is headed Absence of a Causal Nexus. BHP is just a shareholder without powers of management or participation in Samarco's operations. And I think my learned friend showed you that. If you look at 231 at the bottom of the page, BHP Brazil pleads that Samarco has its own legal personhood under the terms of the law, cannot be confused with its shareholder. It's the only owner of the mining assets where the accident occurred before the DNPM environmental agencies, and it performs its activities independently without BHP having daily management over Samarco's operations. And then in 232, Samarco is in reality a joint venture held 50-50 by Vale and BHP. That structure without prevalence of power between the shareholders, combined with the fact that Vale and BHP are competitors, causes the governance and administration of Samarco to be structured in an independent, balanced institutional fashion pursuant to its corporate bylaws, all aimed precisely at preventing interference by the shareholders in the daily operations of the company and preserving its independence.
So it's actually 232 that matters, isn't it? 231 would be true in every case and would mean that the whole case law in Brazil about indirect polluters had no meaning. But you're saying this is a special case.
It is. 232, you're absolutely right, my lord, is most important. It's also, I suppose, the last part of 231, performs its activities independently without BHP having daily management over Samarco's operations. But your lordship is right, 232 is undoubtedly critical. Now, if you assume that this allegation in the defence succeeds, that the Brazilian court concludes that the Samarco JV is structured in such a way as to prevent interference, preserve independence, there's no control by BHP Brazil for indirect polluting purposes, we say it must be the case that a finding by the English court that a company higher up in the chain, like PLC, controlled Samarco through BHP Brazil would be inconsistent with that.
Why? Why can't they say in the English action, well, that's how the documents were set up, but what in fact happened was that control was exercised by the parent companies?
Well,
What's inconsistent between those two?
I think my answer to that would be, it goes back to the risk point. I mean, I suppose that there's, but I don't think this is clear from the MPOC at all, that they're putting it only in the way that your lordship is putting to me. I just don't think that is a fair reading of the master particulars of claim, which is broader than that. I suppose it's conceivable that there is an outcome, such as the one your lordship has just mentioned, in which you end up without an inconsistency. But I mean, that is, in my submission, at the margin, and more likely, bearing in mind what we see here and what we see in the master particulars of claim, more likely you could have an overlap, an actual overlap, where there is an element of this happening through BHP Brazil, and there would be an inconsistency. I mean, if Samarco is set up not to be controlled by its own shareholders, it's very hard to see how a non-parent, a non-shareholder, higher up in the chain, could control it. But as I say, my respectful submission, you cannot read the MPOC that narrowly. The risk of inconsistency is clearly there. Paragraph 233 is also important at page 4005. The attached document proves that Samarco's management and operation are independent from the shareholders pursuant to the corporate bylaws. And you'll see a reference there to the corporate bylaws that BHP Brazil is praying in aid. And so there will be a finding on that point, on the relevance and significance of the bylaws in this context, if the 155 proceeds. And as I'm going to show the court, the bylaws is one of the documents the claimants rely on in the MPOC for their case of control through BHP Brazil. And then if you look at 247, which is at page 4009, that says Samarco performs and manages its operations independently. It's undisputed that unlike what the MPF alleges, BHP did not have any involvement or participation in the operations of the Brazilian miner or in the causes of the event. Now, again, we say very hard to see how there isn't going to be at least a risk of inconsistency between that and what's being said, what would be looked at in England. And then 248, the parties did not intend to establish joint liability for any impacts caused by Samarco's operational activities. Samarco was created with a corporate structure, and corporate governance gives it operational and management independence pursuant to the corporate bylaws without a contractual provision for the joint and several liability of the shareholders for any of the miners' liabilities. Now, so we say, stepping back from this fuller review of the defence, the issues this clearly gives rise to are whether, as a result of its shareholding in the joint venture structure, including Samarco's bylaws, and as a matter of fact, BHP Brazil controlled Samarco, or whether, as pleaded by BHP Brazil, Samarco's independence was preserved. And that's what I call the first layer of issues that we submit also arises, or is likely also to arise, in England. And you can test it this way. Are the matters pleaded by BHP Brazil in its defence matters which would likely be invoked by the defendants in the English proceedings in their defence? We say the answer is plainly yes. These defendants would be likely to make the same arguments or as part of their defence as the arguments that BHP Brazil is making here, and the risk of irreconcilable judgments is obvious. Can I then go briefly to the MPOC, which is, so we can put away Q, and that's in bundle B at tab 17, and it's page 463. And I'll go straight to, in fact, to 464. The now infamous paragraph 275 at the bottom of the page. As you know, that we rely on that express allegation in the first sentence, that BHP exercised ultimate control over Samarco through BHP Brazil. And then they say the ultimate control occurred under the terms of the shareholders' agreement and the bylaws. And that does, in my submission, give rise to what I call the first layer issue, whether the arrangements between Samarco, Vale and BHP Brazil are such as to preserve Samarco's independence or not. And as I say, the bylaws are being relied on in both sets of proceedings. In Brazil, they're being relied on by BHP Brazil, and in England, they're being relied on by the claimants. In one place to demonstrate a lack of control, and in the other place to demonstrate control. Then in the second sentence, it's pleaded that the shareholders had the ability to and did cause the Samarco board to act in certain ways, including through the shareholders' ability to appoint directors. Now, the question of whether that's sufficient to establish control on the part of the shareholders, and that's BHP Brazil, in circumstances where neither Vale nor BHP Brazil can appoint a majority of directors, it is the same in England and in Brazil. Now, we understand the claimant's allegation that PLC itself is said to have in effect controlled the exercise of these rights, but that's a point that goes to what I call the second layer, who was calling the shots within BHP Brazil. Doesn't mean that there aren't overlapping issues in both actions. Can I just draw your attention to a couple of other paragraphs as well? If you look at page 396, paragraph 58, which I don't think you've seen yet, possibly. That says, at all relevant times, BHP's interest in and control over Samarco has been exercised through its wholly owned subsidiary, BHP Brazil, share capital of which is now held by the following subsidiaries, and then it sets it out. So that's, again, a very clear statement or recognition that whatever control BHP PLC exercised, it was through BHP Brazil. And then I also wanted to show you at page 399, paragraphs 72 to 73. You can see that the heading of C.2 is BHP's control over Samarco. You see that above paragraph 71. And then if you drop down to the subheading, C.2.1, the first matter that's identified as being part of BHP's control over Samarco, and we're now talking about PLC and Limited, is the corporate governance of Samarco. So the very first matter that they rely on to establish PLC and Limited's control over Samarco is the corporate governance of Samarco. The corporate governance of Samarco is precisely what I've just shown the court as being an issue in the 155. And you'll see in 72 that there's an allegation or a suggestion that they're going to rely on the full terms of the Samarco SHA. In 73, they also say they're going to rely on the bylaws, and those obviously regulate the relationship between Samarco and BHP Brazil and Vale. And that, again, we say is the same allegation that's being grappled with in the 155. And of course, and those, I think, give you a flavour of the relevant paragraphs of the Master Particulars of Claim. Now, of course, I do accept that in England additional issues arise which relate to PLC and Limited. And that's not surprising because the claimants have set themselves the task of establishing liability against the top companies. They can't stop where the prosecutor stops in the 155. But that doesn't in any way detract from my point about a significant overlap. My learned friend, of course, in his submissions accepted some overlap, and indeed he accepted at day 2, page 191, lines 10 to 13, that insofar as the claimants are relying on the control route for indirect polluter liability, the overlap point could be a very important point. So he accepts that is so, and that is significant. Of course, he says, well, we've got other routes that we can rely on apart from control, but he does accept insofar as it's the control route, the overlap point could be a very important point. And he does also accept, and this is day 2, page 195, lines 10 to 15, that it may be likely that if PLC and Limited are liable, then BHP Brazil may well be liable too. But he said there was no, in his word, was no inevitability about that. Now in my submission, inevitability is not the right test. And that goes back to the point I made about risk. And there is, we submit, a very high risk, and that's sufficient for my purposes. And my other concluding point on this aspect of things at page 198 of the transcript was that he said the highest we could put it was that it's possible that the Brazilian court might say something of interest. And my respectful submission, that's obviously not the highest we can put it. And indeed, my friend himself in his submissions put it somewhat higher at various places, as I've mentioned. So in short, we say there is an obvious overlap, and the risk of inconsistent decisions is very real. So that's what I wanted to say about liability, the liability overlap. Causation and damages, you'll recall that in Judgment 181, the judge said there were many overlapping issues of causation and damage. And we've dealt with that in our skeleton. I'm not going to go to it now, but for the reference at para 164, page 182. And that does give your lordships, my lady, the references to the expert debate about this. And of course, this is an area where I accept there was quite a significant expert debate, and the references are there. I'm going to focus, if I may now, just on what my learned friend said on his feet. First, he made a point in relation to homogeneous individual rights. And he said, well, a CPA is not going to decide individual causation and damages issues. And of course, we accept that those types of issues are issues for individual liquidation proceedings. And we don't rely on those types of issues as being overlapping. But you'll have seen our evidence, which is that even for the purposes of a generic sentence, the court will make causation findings of a general nature, including so as to give guidance to judges in liquidation proceedings. And I accept that's a point that's disputed. We can obviously add that to the schedule of references, but we've also dealt with it in our skeleton. There's also the generic causation and damages issues which arise from the in-kind relief in the 155. And we say that those heads of relief will give rise to causation and damages findings, which will overlap with causation and damages questions that arise in England. Now, my learned friend made 3 points about that. He said, first of all, that there are no in-kind reliefs sought in England. Well, that's true, but we submit irrelevant. What matters is whether the in-kind reliefs sought in Brazil give rise to issues which will also arise in relation to the claims that are made in England. We don't have to show that the claim is precisely the same. We have to show that there's an issue that will arise in Brazil that will overlap in England.
What issue will that be?
Well, as I said, to give an example, if you had a claim for in-kind relief in Brazil, such as to clean up a section of the river, or to or to deal with toxicity in a particular area, if the court decided to grant that relief, it would necessarily have to reach a conclusion on generic causation about whether the tailings reached that area and whether the tailings had an effect on toxicity such that a clean-up order was required. If the court makes those kinds of decisions in Brazil, those will undoubtedly overlap with issues that will arise in England in relation to the claims that are brought in England, because the claimants say in England, we're entitled to compensation for what's happened to us, and that will necessarily also raise the question of whether the tailings reached particular areas where the claimants reside or have their businesses and so on. So that's why we say those issues are very much overlapping issues. My friend's second point about this was that he says, well, it's impossible to know how extensive that overlap is. And that's where we rely on the evidence of Mr. Vivan, who has analysed both sets of pleadings in England and in Brazil, and identified the generic issues and set them out. That's Vivan 1, paragraphs 206 to 207, which is bundle I, tab 29, page 1495. We submit it is possible to be confident that the generic issues identified in the evidence will arise. And the third point that my learned friend made was that it's difficult to make predictions given the extensive works that Renova's been carrying out. And we accept, of course, that Renova's ongoing work may address some of the damage in a way that satisfies the prosecutor. But absent a settlement of the 155, there's no reason to believe that all of the prosecutor's complaints are going to be addressed in that way. So that's what I wanted to say about extent of relatedness and risk of irreconcilability. I move on then to the second point that arises under 34.1c in discretion, which is the connections between the facts and the parties in Brazil. And obviously I can deal with this very, very shortly. This is in our skeleton at paragraph 167 for your reference. This is obviously an important consideration. It's included in both the factors specifically identified in recital 24, as well as in the factors identified by the Advocate General in the Owens against Bracco case that I referred to. In my submission, all I need to say is that the connections with Brazil are overwhelming. That close connection to Brazil is a relevant consideration because it demonstrates that it's the Brazilian court which is clearly best placed to decide the overlapping claims and issues. And that was the point that Advocate General Lentz made in that sentence that I showed you in the judgment of Lord Clark, where he said it is relevant to take into account which court is in the best place to decide, best placed to decide. So that's all I wanted to say about the connections.
That depends to some extent on the first point, because we're not concerned with quantum issues here. We're concerned with liability issues. There are obviously some liability issues here which are English-centric. But if you're right about, for example, 155 deciding generic causation issues, they're obviously very Brazil-centric.
Indeed.
But,
So your lordship is actually right. There's obviously a connection between an interrelationship between that point and the first point. Of course, we say there is a significant overlap on liability, and there's a significant overlap on generic causation and damages issues, and on the bits that overlap, it's the Brazilian court that's best placed to look at these things. Certainly on causation, of course, but also on the overlap on liability, because that is concerned with the operation of a Brazilian joint venture mining entity and the corporate governance of that entity and the relationship between that entity and its two Brazilian shareholders. Now, I accept, as I've already said, that of course additional issues arise in England as to the extent to which PLC and Limited were actually directing the whole thing.
But isn't it also significant in that context that how the very general terms of the indirect polluter law applies in any kind of corporate structure, in particular in this one where there's a 50-50 joint venture, it appears to be, as far as the evidence goes, a completely novel point of Brazilian law. There's the single judgment of Judge Benjamin, which is at a high level of generality, and it's more appropriate that a Brazilian court decides that point of Brazilian law than an English court.
It's a hugely significant point. I entirely agree. It's a hugely significant point that something like that arises and should be dealt with by the 12th Federal Court and the courts in Brazil, and not by this court. It's a very important point. I agree. And of course, there is also our case, which I'm coming to, about consolidation, because if it were possible, we say it is, if it were possible to have consolidation where a single forum in the natural forum, Brazil, could look at all of these issues, including the PLC and limited issues, that would undoubtedly be the best possible thing for the proper administration of justice. And that's why we did run before the judge, and we still run now, a case based on consolidation. Can I, before I turn to consolidation, can I deal with the third point, which is wait and see, and what we say are the reasons for a wait and see stay. And some of these I've addressed already, so I can take more shortly. As you know, the claimants submit that a wait and see stay is pointless, but the judge concluded that actually it was amply justified, in particular at Judgment 228. He said, well, apart from anything else, it will avoid the conduct of parallel proceedings and all of the practical difficulties associated with that, and we support that conclusion. And we also make some additional points, which we address in our skeleton from paragraph 169.
Sorry, just, this is a wait and see stay until the conclusion of the CPA, which, assuming there is a generic sentence, is concluded by the generic sentence, is that right? So
yes.
We're not looking at any questions of parallel proceedings on the quantum side. Are we? You're only waiting to see, you're only waiting until the end of the generic sentence. And then you're reviving here.
Well, that begs the question whether you'd be reviving here, which I'm going to come to, whether the case would actually need to carry on or not, and I'm going to come to that. But your Lordship is right. We say, we ask the judge, till the stay would last until the conclusion of the 155. That means either by a settlement, a TACF, or by a judgment in the main action that would give rise, as your Lordship correctly says, to a generic sentence. We're not suggesting it goes beyond that. For example, if one of the priority axes for some reason continued beyond the end of the 155 main action, because for some reason it was felt to be needed, we're not suggesting...
You say for some reason, that's actually quite a likely outcome, isn't it?
It may be, but we're not suggesting that that here and now we can ask for something that goes beyond the end of the main 155. And equally, I think it was suggested at one point, what would happen if there is a settlement and it contains a mechanism whereby disputes in relation to the implementation of the settlement could come back to the court. We're not suggesting that would therefore, if you like, extend the period of the stay because somehow the 155 would still be alive. We are only going up to the point of the end of the 155, the main action. And I go back to, just in answer to my Lord Justice Popplewell's question, this is why this point about generic causation and quantum issues might be quite an important issue, because if we're right about that point, then the 155 is not limited to liability. It is going to make conclusions. It is going to give rise to conclusions and findings on generic causation and damages issues. And therefore, that is, to that extent, you are talking about parallel...
I understand that. I just thought your submission was, look at all the problems the judge identified in parallel proceedings going on together, and they don't all apply in this context, do they?
Understood. So in terms of the additional points we make beyond where the judge came out, if you like, in 169 and 170 of our skeleton, the point we're making, the nub of it, is that if a stay of the English action is granted or if the appeal is dismissed in this regard, then it's unlikely, we submit, that the action will have to resume at all in England thereafter. And obviously, if that's right, then that's an important factor in favour of a stay. And in fact, in the Jalla case, Mr. Justice Stuart Smith recognised that the possible abandonment of the action in the member state would be a relevant factor as regards whether to grant a stay, if it just wouldn't be necessary to resume in England after you've waited for judgment in the third state, then that would be a factor in favour of a stay. Now, the reason I say that the English action is unlikely to resume after the conclusion of the 155 is that there'd be no point in its resumption if, on any view, including that of the federal prosecutor and of the 12th Federal Court, appropriate compensation was then available in Brazil through efficient and fair processes. Once the 155 CPA is resolved, be it by settlement or by judgment, and I'm going to deal with each of those scenarios in turn in a moment, it's very hard to see what further need there could be for the English action. Now, of course, I'm not suggesting that's a certainty, but I do submit that it's likely, or at least that there's a real prospect of that. The English claimants would be likely to make use of the improved redress mechanisms in Brazil instead of pursuing uncertain litigation in England. Now, let me develop that a bit by reference to the two possible ways that the 155 might be concluded, a settlement or a judgment. Let's suppose a final settlement agreement emerges in the 155. That's going to resolve once and for all the prosecutor's complaints about Renova, including as regards the indemnification of impacted people. Everyone agrees that if there is a final settlement agreement, it will have been negotiated on the basis of the principle of full redress. Point one. Point two, it will have been negotiated with the involvement of the relevant stakeholders, including the public prosecutor, who the claimants say is an appropriate representative for their interests. And point three, we know from Caliph at paragraph 14 that the negotiations are directly considering how to improve and accelerate the redress provided by Renova, including compensation to affected persons. And indeed, at paragraph 16.2.1, he says that meetings that have taken place have already included discussions about indemnification of affected persons. Now, you'll have seen, I hope, from our skeleton at paragraph...
And sorry, this is all post-judgment material, so this is assuming that we are setting aside the judge's decision and starting afresh, is that right?
Well, in relation to my lady is quite right, in relation to a specific point like meetings have taken place that have discussed indemnification of affected persons, I entirely accept that would post-date. But the point in principle...
Conceptually, yes.
Conceptually, it would still be something as at the date of the judge's judgment. Conceptually, what would be the impact of a global settlement if one emerges in the 155? Can I just invite your attention to 169A of our skeleton, which is at the bottom of page 184, going over to the top of 185. It's the very last sentence at the bottom of 184. Now that says that the possibility of a settlement in the 155 causing the English action to be abandoned is acute. It was recently reported that a municipality's representative in the negotiations has indicated that in the event of a settlement, they may withdraw their English claims. Now,
what are we supposed to do with that sort of statement?
well, let me,
Sorry, it's a recently reported, is a newspaper?
it's a
It's a formal statement?
I think it was an article, newspaper article, reporting on a statement by the former mayor of Mariana. So we're talking about someone right in the heart of the action, if I can put it that way. He was actually the mayor when the municipality commenced the English action as one of the 58, and he now represents the municipalities in the settlement negotiations.
Well, the first thing to ask is have we got this article?
Forgive me, my lord, I didn't hear.
Have we got this article? Where is it in the bundles?
Yeah, we do, and I'll
I don't think there's a reference. If there is,
let me find the reference. I'm sorry if it's not in the.
If it's important, is this an important point?
It's an. I'm not suggesting.
Multiple.
no.
This is someone. He's given.
Share my lady's concerns, but you are making the point.
I am making the point. Absolutely. It's. Let me put it this way. It's an illustration of why the point I'm making about abandonment after a global settlement is not a fanciful point. It's not just an advocate's point, if you like. It is a real point. That's
Okay.
why I'm using it.
Well, we've got the point, but all we want to think. Speaking for myself, I'm not going to go on. I can't at the hearing because I haven't got correct connections. Not afterwards to go and read an article in Portuguese on the website. So we must have a printout.
Yeah, we do. It's in bundle N for November, at tab 50, page 2969.
Yes, it would be useful if that had been referenced, but there you are. I think
I
you've done a
apologise
huge
for
job,
that.
so that's fine. Okay.
And it's actually the relevant bit is in the second paragraph. In the middle of the paragraph, according to Duarte Jr., quote, the amount stipulated is 137 billion reais. And if signed, this agreement will be the largest in the world, and municipalities may even withdraw from the action in England. Now, of course, I entirely accept that that's dependent on what the settlement, whether the settlement's satisfactory or not, and what size it is, and so on. But that's in a sense, that's the point. I can't say now that there will be a settlement at all, or whether, this particular municipality will be happy with the settlement. What I can say is that there is reason to believe that that if there were to be a global settlement that everyone buys into, all relevant stakeholders, that will have this effect, that people will then be able to get redress that they're happy with in Brazil, and then a real possibility of abandonment in England. And that statement does also emphasise the closeness of the relationship between the 155 and the English action in practice. Now that's settlement. So far as a judgment in the prosecutor's favour in the 155 is concerned, that does have a number of important effects, which you've heard about. We summarise those effects, if there were to be such a judgment, at 169B of our skeleton at page 185. They are basically court-ordered improvements to Renova, number one. Number two, a generic sentence. Number three, findings on causation and damage. And number four, in-kind relief, from which all claimants, including the 58, would benefit. What we say is that even if some claimants in England are unwilling to make use of Renova now, it's very difficult to see why they would not make use of an improved Renova scheme following judgment in the 155. And so that's what we say about a judgment. And of course, we accept that if a judgment is adverse to the NPF, then it won't be binding on impacted people. That's the way that a CPA works. We accept that. That's intended to be favourable to claimants, to impacted people. That's, in my submission, not a reason not to grant a stay. There is, of course, the claimants say that the CPA will be one, and if it is one, then there's all the benefits that I've mentioned. So the fact that that's the way a CPA works, we say, is not a sufficient reason to not wait to see what happens because of all the benefits that I've just identified. Let's assume for a moment, though, that I'm wrong in the submission I've just been making concerning the likely abandonment of the English action. Let's assume instead that some claimants wish to continue with the English action even after a settlement or a judgment in the 155. We say even in that scenario, there's reason to think it would have been worth waiting for the conclusion of the 155. That's because we say there's every chance that any action which then continued in England would be smaller, brought by any claimants that wish to proceed despite the resolution of the 155, and it would be more manageable. And if it was resolved by judgment in the 155, that judgment would have addressed and resolved many of the important issues which would otherwise have arisen in the English action. And that's what we deal with in our skeleton at 171. And there's basically really 3 points that we take. First of all, if you had a judgment in the 155, that would narrow the English action, A, because some claimants would fall away because they'd be happy with what the position was in Brazil, and B, because those that didn't would be realistic about their arguments in light of the findings of the 12th Federal Court following a full trial. Secondly, the Brazilian court will make findings of Brazilian law, in particular as to the requirements of environmental law to establish an indirect polluter. Now, and that's a point I've already touched on, it must be preferable for the English court to wait for the Brazilian court to consider the issues that we've already discussed because of the importance of them for this case. I think my learned friend said the Brazilian court won't look at the position of shareholders higher up the chain because they're not in issue, and I accept that. But what the Brazilian court says about control in the context of BHP Brazil is highly likely to be relevant to PLC as well, for reasons that I've already addressed. It's the same law that's in issue in both places, and what indirect polluter means in the context that we're dealing with will be addressed by the 12th Federal Court. And of course, everybody accepts that the Brazilian court's findings on law would be something that could be relied on by an English court, and we've set out the authorities on that in our skeleton. Now, I think my learned friend suggested that the court would only admit expert evidence of foreign law on the principle, but not on the application of those principles. And there's just 2 points I wanted to make about that. First of all, the court would be entitled to be told by an expert, including by reference to authority, what a foreign statute meant and how it had been interpreted in the foreign jurisdiction. So clearly, if there'd been a relevant decision by the 12th Federal Court, expert evidence about that could be given here. And that just if you're interested, we've included Dicey on that point at tab 8 of the bundle that I handed up with the Travaux Préparatoires. So it's in tab 8 of that. It's Dicey paragraph 9019. But there's also a second point, which is, I think my Lord, the Vice President made this point, that the line between principles and application is not, in any event, clear-cut. And that's expressly referred to by Phipson, and we've included that. It's paragraph 3394, and we've put that at tab 9 of the bundle of Travaux, and that's expressly stated by Phipson that the line, that there isn't a neat dividing line between principle and application when it comes to expert evidence of foreign law. And then there's a third point we make, which you've seen from our skeleton 171C, which is where the Hollington and Hewthorne debate arises. And I don't think I need to go into the detail of that. What you'll have seen and what I'm sure you're familiar with is that there's been a dilution of the rigour, if I can put it that way, of Hollington and Hewthorne in recent cases, and we've set them all out in the skeleton. It's clear on the authorities now that you can certainly refer to a foreign judgment. The English court can rely on a foreign judgment if it has a record or a recitation of evidence that was given in the foreign court. So that much seems to be clear on the authorities. There's actually a decision of Sir Ros Cranston, which goes further and says where it's fair to do so, the English court can consider the findings of the foreign court as well and give them such weight as is appropriate. And then there's a later decision which says, well, that's not clear cut, and that should be looked at in more detail by a court when the point arises. So the precise scope of the dilution of Hollington and Hewthorne is not settled, if I can put it that way. That doesn't matter for the point that I'm making, because certainly the court can have regard to the judgment. It will be able to have regard to it for evidence that's recorded in the judgment, and it may well be that it can actually have regard to the findings if it's right that Hollington and Hewthorne doesn't prevent that. And there is another point I just want to add before I finish wait and see, which is if the action in England is not stayed, there is going to be a new front opened up. and that is certain to disrupt the efforts that are being made in Brazil. And I know this is a point Mr. Gibson's already made, but it does apply in the Article 34 context as well in my submission. Instead of everyone's focus being on Brazil and Renova and the novel system, the claimants and other stakeholders will have an eye on England and what they might be able to achieve here. And the judge was, in my submission, rightly very concerned about that. You've seen the bits of his judgment where he expressed that concern.
I see you're moving quite fast, and that's understandable. We do need enough time for Mr. Gibson on form conveyance. Have the two of you got a joint timetable, and are you within it?
We have, and I'm going to move as fast as I can. I've got a little bit more time, a little bit more to do.
Okay, that's fine.
I will certainly leave enough time for my other friend to address you on form non-conveniens and the other points he wants to address you.
Can I be a nuisance and slow you down? Just on what's meant by the wait part of wait and see and how long it might take. We've got the rival evidence on Mr. Viven's 2 to 4 years after negotiations finish, and rival evidence on that. But then that's going to be a first instance decision, is it? So there's an automatic right of appeal to the second instance court in CPAs. And have we got any statistics as to how long that might take, or any evidence about how?
I don't think we've got a prediction, if you like, along the lines of the 2 to 4 years. What we do have some evidence about how long appeals can take in the context of large CPAs, and I can give you the reference to that. I think broadly speaking, they can take a number of years. And I'll try and get you the reference for that. So
and is there an automatic right of appeal to the superior court as well?
I might have to come back to you on that. I don't know the answer to that, whether that's automatic or whether there's any permission stage.
But obviously, how long the wait is an element in the discretion for wait and see as a
It is.
as a factor.
It is, and I accept that. So I'll come back to you on whether it's automatic at both levels.
Thank you. And then just the references for any numbers, as it were, that anybody's given.
I don't know whether this would be useful, but I just throw it out in case anyone wants to pick it up. If the wait and see, if the stay were said to lift at the conclusion at first instance, there would then be a review, or the opportunity for a review of whether it should continue pending the appeal, assuming there's going to be an appeal.
That's true, and indeed, for the reason I gave earlier, whatever the order says about a stay, you can always come back anyway, because Article 34 itself says you can come back. If something changes that means it's no longer in the interest of the proper administration of justice. So yes.
It would clearly be difficult, I think, for a court which is told there is an appeal to say, well, I know we said wait and see till first instance, but we're not going to say wait and see till an appeal.
Well,
but
I see that.
One might, because
But
the balance
might.
of considerations
And you
might
could certainly,
change at that point.
Indeed, and you could certainly review at that point.
Yes, okay.
My Lord, on consolidation, my Lords and my Lady, on consolidation stay, and this is also relevant to foreign non-conveniens, because of course the point as to whether a new CPA could be brought in Brazil against these two defendants, that's relevant both for consolidation stay in Article 34, but also relevant in foreign non-conveniens. And you'll recall from the judgment that the judge basically decided he wouldn't decide this question because he felt it was there was no point deciding it, because he felt it wasn't going to happen. In other words, that the claimants were not willing to try to make it happen. And therefore, he felt there was no point staying to facilitate consolidation, because the claimants weren't going to make it happen. And that's dealt with in judgment 212 and 213 and 216 as well. And therefore, he decided he wouldn't decide about consolidation. Now, we submit that if it's practicable to launch a new CPA against these defendants in Brazil, in the 12th Federal Court, which could be consolidated with the 155, then the fact that the claimants or particular entities within the claimants, such as the municipalities, don't want to do it, is not a reason why we shouldn't get a stay on that basis. That if it's practicable and it makes sense for the administration of justice, then their own, as it were, desire to do it or not to do it oughtn't to, as it were, carry the day.
Just remind me that the finding that the claimants weren't going to do it anyway was based on Mr. Hollander's submission or something in the something else in the evidence.
It was certainly based on his submission. Whether it was based on evidence as well, I think in a sense it was based on evidence, because the municipalities, for example, were putting forward evidence that said, well, we don't want to do it. We don't want a new CPA, or if we did, we would, if we did bring a new action in Brazil, we'd want to do it in our own state court. We wouldn't want to do it in the 12th federal court, that kind of thing. So there was a lot of obstacles, if you like, that were put in the way of a new CPA. But we submit that all of them are surmountable, and actually not difficult to surmount at all on the evidence, and that this really came down to a wish on the part of the claimants to be here rather than there, but not something that goes to practicability. And what we need to show on the authorities is a real possibility of consolidation. That would give us a strong factor in favour of a stay. We don't have to show certainty of consolidation. A real possibility is how Mr. Justice Fancourt put it in the Kolomoisky Privat Bank case at paragraph 145. When the case went to the Court of Appeal, the Court of Appeal didn't suggest he was wrong about putting the test that way. That's in paragraph 210 of the Court of Appeal. So we need to demonstrate a real possibility. Of course, if the rules, the procedural rules of the third state don't permit consolidation, as indeed was the case in Privat Bank and in Jalla, two of the cases that concern Article 34, then there's no real possibility of consolidation. In our case, you have a situation where the procedural rules do permit consolidation, so we get through that hurdle, and plainly, if you can get there practicability-wise, it would be in the interest of justice and the administration of justice, because you then have one forum looking at all issues. Now, can I, what I want to invite your attention to, because I'm concerned about time, is bundle Q at tab 94, because in a bid to make this much quicker, we have set out a document. It's only 4 pages, which explains our case on how a new CPA could be brought in Brazil against these defendants. And we did put something very similar in before the judge, but we have redone the document now because we were conscious that the court would want the references not just to our evidence, but would want the references to any controversial points, would want the references to all of the evidence, if you like. So this document does contain all of the controversial points, insofar as there were any, and gives the references to both sides' evidence, and explains why we submit a new CPA could be brought and that it is practicable. And I believe, although I haven't seen this yet, that the claimants are planning to respond to this document. We provided this document to my learned friend yesterday. I haven't seen any response, but I believe that's the intention. One of the key points we make, and I don't think there's time for me to go through all of this, but one of the key points we make as an overarching point is that you can have multiple, and this is not disputed, you can have multiple claimants bringing a CPA, so long as they have authority standing under the law to bring a CPA. You can have more than one claimant bringing a CPA. So by way of example, you can have the 25 municipalities bringing a CPA together. Bear in mind they are claimants in England. They could be claimants in a new CPA in Brazil. They can act for everyone, at least within their own districts they can bring a CPA on behalf of everyone within their own districts. Now, if they do that, then that's 96% of claimants covered, simply by 25 municipalities starting a new CPA in Brazil.
Which paragraph do we find that in?
So you'll see that in paragraph 5.
Thank you.
Be careful to be claimant by claimant again. Suppose the municipalities choose not to do so.
Well,
What's to happen to the other claimants?
Well,
They
that's
don't have any control over it.
But that's when I come back to the point about, and you'll see this in this document. First of all, I make my point about if you choose not to do something, that doesn't necessarily really provide you with an answer to my
This is somebody else choosing not to do something. This is the other claimants in a position where the municipalities choose not to do something.
I see that, in which case we've set out here other ways this could be achieved. For example, you are perfectly entitled under Brazilian law to form an association. Anybody can form an association, and an association has standing to bring a CPA.
After a year, and there's a dispute about whether that would be waived.
Well, not really. If you look at the references we've given, it's accepted that can be waived, and Professor Didier is very strong on saying it would undoubtedly be waived. So you're right. There is that wrinkle.
Well, and I think there are arguments on whether you could form an association having the necessary commonality of interests amongst all the disparate groups and claims.
And you'll see,
all the claimants.
your Lordship is absolutely right, and we've in paragraphs 9 to 11, by way of example. And unfortunately, I wish I had more time to do this in more detail, but we have set out in those points that you're.
Oh, sorry, I haven't read the documents.
Not at all, of course.
Maybe wasting your time.
Not at all. So if you look at 9 and 10 and 11, we deal with associations, and we do grapple with the points that are made about what limitations there might be on an association bringing a CPA, by way of example. So we have set that out here. We also have set out, if you look at page 3, we've dealt with the argument that's made about unwillingness to bring a new CPA, and we deal with that. We deal on page 4 with consolidation, in other words, whether the action, if it was brought, would be consolidated in the 12th Federal Court with the 155. And we also deal with duration. And so I appreciate it's not a particularly satisfactory way of doing oral advocacy to say here's a document, but in the interest of time, that does set out our case. We do say that when you look at the points, it is entirely practicable to make this happen, and that it really would be the best way of resolving the problems in this case. And so that's what we say about a new CPA. And then point 5. Just one minute. Point 5 that I wanted to move on to is the timeline and the stage that's been reached in Brazil. And this is obviously a relevant factor. It's one of the factors in recital 24. We do submit that the action, the 155, is more advanced than the action in England. You'll have seen, and very briefly, you know all of this already, but defences have been filed, experts have been appointed, several expert reports have been completed, important interim agreements have been concluded, such as the GTAC and so on. Global settlement negotiations are ongoing, whereas in England, obviously, we are where we are. In relation to the fact that they have been stayed, we accept, of course, that they have been stayed, and that they've been stayed for a while now. It's easy to say, well, you know, does that make sense? In my submission, it all depends. I mean, if you end up with a global settlement agreement that everybody buys into, there could well be a situation where you look back and you say, that was time very well spent. This is a very, very complex problem. It required engagement from all kinds of stakeholders, and we ended up with a global settlement, and that was time absolutely well spent. So I appreciate looking at it now. We're looking at a situation where the claim hasn't moved forward, but if...
Well, we have to be careful again not to compare apples with pears. We're looking at the relative stage of that part in respect of which there's an overlap and which might provide some assistance at the end of the wait-and-see period in England. And so far as that's concerned, if it were the case, for example, that the only relevant overlap of any benefit would be the liability of the Brazilian companies, it's not gone any further than you get, indeed would already have got so far for these applications.
Well, then I go back to the point I made about, is it really the case that England would resume in its full form as now constituted after a successful settlement or judgment in the 155? My submission to your lordship, to the court, is that that's not realistic, because things will have moved on positively in Brazil in such a way that it won't be necessary for some or even all of the claimants to pursue the claim that they are now pursuing in England. And that's the abandonment point which I addressed. Just before I move on with timeline, I should have said in the context of a new CPA that in case there's any concern about limitation, because it's a point that I know arose yesterday, that's something that I can deal with very briefly. It's not been raised, but assuming that the appeal was dismissed on Article 34, the defendants would be willing to accept that their limitation argument in relation to any new CPA would be no better than the argument they already have available to them in England, provided that the new CPA was brought within 1 year of the final determination of the English court to stay or strike out the English proceedings. And we can make available to the court and to my learned friend a precise form of words, but I've just summarised effectively what the point is. So we wouldn't put ourselves in a better position, limitation-wise, so long as the new CPA was started within 1 year.
I don't know how central it is, but if you are going to do that, you must do a precise form of words and do it quickly.
Indeed. And it will say what I've just said, but we will do that. We'll let the court have that, my learned friend have that. So can I then just deal with whether judgment will be within a reasonable time? Now, you know our evidence is 2 to 4 years. That's Mr. Vivan 1 at paragraph 296.
From the end of negotiations.
It's the end of negotiations, which you know Mr. Califf says is going to be the middle of this year. So we say it's 2 to 4 years from the middle of this year. Your Lordship knows we say there's no stay in place at the moment because the stay has expired. But we accept the negotiations are continuing. The evidence before the court is they're likely to come to an end middle of this year.
And it's accepted, I think, isn't it, that whether or not the stay is in place, nothing's going to happen until the end of the negotiations.
Yes,
at least if Mr. Califf's estimate is correct.
Yes, so that's right. Now the claimants make a number of points about the 2 to 4 years. First of all, they say they challenge the estimates. Now the important thing to note about that is Mr. Vivan has a detailed knowledge of the case. He's actually the lawyer instructed by BHP Brazil in the 155. He gave a detailed explanation and justification for his estimate. He drew on matters such as the fact that dam-related cases in Brazil are being...
So what, you're asking us to determine outright that he's right?
Well, I'm asking you to accept that his estimate is a reasonable one for the reasons that he gives, and he does give a detailed explanation of why he's come up with that figure. The references, I think you have them, but they're Vivan 1, paragraphs 292 to 301, Vivan 2, especially paragraph 393. We do say his estimate's consistent with the way things have been going in Brazil and Judge Mario's comments on the need for expedition. But importantly, and maybe this helps with my lady's point, his estimate is consistent with evidence as to the general length of CPAs. And you'll recall that Justice Rezek explained that in a sample of 100 randomly chosen environmental CPAs in Minas Gerais, the median length of time was 2 years and 8 months.
Well, that's a bit meaningless. And Dr. Jano says, look at a particular dam-related one, and it took 10 years or 12 years, something like that, to get to a judgment, and the appeal was still pending 4 years later.
Well, I'm not sure that he refers to a dam-related one, but he does. You're right to raise Jano. Let me deal with that straight away. First point I make about Jano is he took no notice of what was actually happening in the 155. unlike Mr. Vivan, who did, and explains what he's done in relation to taking that into account. Second of all, the basis for his view was a list of 15 CPAs set out in Appendix 2 of his report, which had taken a very long time. Those appear to have been cherry-picked and provided to Dr. Jano, not representative or illustrative, and they don't tell us anything about what will happen in the 155. And the judge already came to that view. If you look in, and I don't invite you to look now, but in the second part of footnote 5 to paragraph 2551 of his judgment, he says that he's not happy with, and he was right to reach this conclusion, with Appendix 2 of Jano's report. And the judge gave a reason for that, which is that Dr. Jano's evidence didn't explain the criteria by which these 15 CPAs had been identified. And in fact, the judge actually asked a leading counsel for the claimants in Manchester to identify the criteria, and he was unable to do so and didn't do so. So it's just a selection cherry-picked by the claimants or by their lawyers and then given to Jano, and that's what he's dealing with. So that's what we say about that. And we'll of course, on
the passage I had in mind was paragraph 98 of Jano 1, following the Cataguases, forgive my Portuguese, dam collapse in March 2003.
Okay, but then I forgive me, my lord, your lordship is right and I'm wrong in relation to whether it's a dam-related point. But I think the points I've been making about his evidence still apply in relation to, because I'm making them about all of the CPAs that he deals with in Appendix 2 of his report. And then I just move very, very quickly, just on the appeals in CPAs, my Lord Justice Popplewell's point, the answer to that is that the evidence such as it is on that is Resec 2 at paragraph 88, which is bundle L, tab 38, page 2522.
And there's a response. There's something on the appellant side as well.
Well,
we have the reference for that.
I'll try and find that, my lady. And then point 6 is the local commissions and priority axes. Now, you know, I think you know that there was a characterisation issue as to whether they were part of the 155 or not part of the 155 and so on. Now, we say that doesn't matter because they're closely related to the 155 on any view, and therefore they can be taken into account and must be taken into account when assessing the proper administration of justice and the exercise of discretion. Now, my learned friend says, well, if they're not part of the 155, then they're simply outside of Article 34. We say that's not right. We're seeking a stay in favour of the 155. We satisfy the threshold conditions under Article 34 by relying just on the 155. But when it comes to the proper administration of justice, the exercise of discretion, all the circumstances of the case must be taken into account. We can therefore ask your lordships and my lady to take into account the PAs and the LCs, and indeed it would be artificial to shut one's eyes to them. As to why they support a stay, in summary, we submit it's worth waiting for those processes to play themselves out rather than embarking on the English action now. That is likely to benefit the claimants and avoid the risk of matters that are being addressed in the PAs, such as the water quality in the Rio Doce being decided both in Brazil and in England.
But that assumes that they'll all have played out by the time of a generic sentence in the 155 CPA, doesn't it?
So I didn't hear...
That assumes, you say wait till they've all played themselves out. The relief you're asking for is only wait until the generic sentence in the 155 CPA, and they're unlikely to have played themselves out by then, aren't they?
My engineer tells me that if you look at Vivan's evidence, his estimate for the PAs produces a timeline that would resolve the PAs prior to the conclusion of the 155.
That may be so, but there's no rational connection. I mean, that's just purely arbitrary. You're taking the generic sentence or settlement in the 155 BN, 155 CPA, if the real point of waiting is to allow the priority access 7 individual claims to be resolved.
Well,
There's just there's no necessary connection between the two.
Well, the way I put it is to say the stay relates to the pending action, but one benefit of staying pending the conclusion of the pending action is that in the meantime, if not all, then at least many of the priority access will have been resolved, and the benefit that will bring to the claimants will be significant. That's the way we put it. And the only other thing I want to say before I sit down is that that's everything on Article 34, but we do have a case management stay application as well, which the judge dealt with. We've set out our case on that in our skeleton, and I didn't have anything to add on that, but we do still press the argument that we make in the skeleton in relation to a case management stay. Unless I can assist the court, that's everything on.
Okay, thank you.
Excuse me, my lord, 1 minute, please.
I think while you're sorting yourself out, Mr. Gibson, there's appeal material, isn't there, in Dr. Janet's report at paragraph 68 through to yes, on and onwards in bundle K 2317.
And just also while Mr. Gibson is sorting himself out, I think what I'm going to do with my bundle P, unless I'm told this will create problems, is simply take the missing ones from the new bundle P, which are tabs 70 to 76, and put them in the front of the new bundle P. And then I'll have it all in one place. Right.
So just before you start, I don't know whether this is a question for you or for Mr. Toledano, but if there were to be a stay under Article 34, and that's on the hypothesis that you failed on abuse, would it then be open to you, when the stay came to be lifted and this action were going to go ahead, to rerun abuse in the light of what had happened since? In other words, does a case management stay in fact, does an Article 34 stay in fact, sub silentio, last potentially, not just until the end of the generic sentence, but actually then until the end of what might be a very lengthy argument about what the effect is of FTAC and all the judgment on the adequacy of the redress, which ex hypothesi, if we get to here, we would have rejected as being sufficient to make it abusive at the moment.
One moment. My lord, the current view in answer to the question is it would depend obviously significantly on what the judgment actually said.
And the settlement.
And the circumstances.
Which may precede it. Well, I may get settlement and judgment.
Indeed.
I may only get settlement. But the tenor of some of Mr. Toledano's submissions was, whatever inadequacies there might be now, it's realistic to think that the result of the process at the end of it will be entirely satisfactory for redress. And I suspect you're not in a position to say to us now, no, we don't promise we won't come along.
I mean,
when the stay comes to be lifted, look at what the situation is now. Whatever you said then, it's abusive now.
That is why I'm hesitating, because obviously I can't foresee exactly what the position will be. But it might be relevant to something which I was going to come to in relation to the disposal of the abuse, which, if I may, I'll come to at the end of FNC. So, my lords, my lady, for and non-conveniens, This is addressed in our skeleton at paragraphs 192 to 225, and it's addressed fully there. But there are relatively few points that arise on it, and of course my learned friend hardly dealt with it at all. It might be helpful just to go to the judgment and start with stage 1. And there's really one point, as I understand it, of attack on stage 1 of the judge's judgment, and it's that he failed properly to apply the Vedanta test. He misapplied the Vedanta test. He should, in effect, have treated the prospect of joint separated proceedings as a trump card. What I understand is, in effect, being saying under stage 1. So if one looks at the judgment, page 279 of the bundle, paragraph 238, he identified 4 factors which were cumulatively significant, as the judge put it. The tort took place in Brazil, referred to Lord Mance in VDP Capital. The governing law would be that of Brazil. The court in England would be far less accessible to the majority of parties and witnesses. And then what I would submit is a very powerful and important point, and a very rare point in a forum non-conveniens application of this, certainly of this type. Judge Mario has acquired a detailed knowledge of the complexities of the claims made in Brazil, and so on. And I could add to that the local courts have as well. So those were his 4 main points, which he identified cumulatively. He then set out the key passages of the Vedanta judgment in some detail. And just to draw your attention in paragraph 240 on page 280 to the quotation from Lord Collins in the Ultimo case, about 8 lines up from the bottom of page 280. The task of the court is to identify the forum in which the case can suitably be tried for the interests of all the parties and for the ends of justice. That is the ultimate exercise, as the court well knows. And again, you see that at the bottom of paragraph 68 of the judgment from Vedanta at page 281. The concept behind the phrases forum and the proper place is that the court is looking for a single jurisdiction in which the claims against all the defendants may most suitably be tried. And again, the position in Vedanta, as the judge found at the bottom of paragraph 71, was that the alternative, 2 trials on opposite sides of the world on precisely the same facts and events, is unthinkable. And then finally, worth just noting, paragraph 79 of the judgment on page 283, where, having identified the choice, the fact that it was in effect the claimant's choice to create the unthinkable, Lord Briggs said, "In my judgment, there is good reason why the claimants in the present case should have to make the choice, always assuming that substantial justice is available in Zambia, which is a necessary but hypothetical predicate for the whole of the analysis of this issue."
Sorry, but I'm being a bit slow. The alternative forum that we're looking at for the purposes of this is a new CPA joined to the 155
Yes.
CPA.
Yes.
It's not a new action in the local courts against.
It could be as well. That is the subject matter of our latest concession, which was in the letter that the court received. So, just to go. There were three undertakings before the court, which we referred to and gave the references for in paragraph 206B of our skeleton. The first was that BHP Ltd and BHP PLC will not contest the jurisdiction of the Brazilian court should their present applications in England succeed, and the claimants, or those representing the claimants in Brazil, commenced the same claims against BHP Ltd and BHP Brazil via a new CPA in Brazil. Then there was an undertaking to accept service of that new equivalent CPA in Brazil. And there was also an undertaking to accept service of any liquidation proceedings stemming from that new CPA in Brazil. And the the letter, if should this court consider a broader undertakings are required, the letter of the 30th of March, which is at Q/85/4239, makes it clear that the undertaking could now cover, if the Court of Appeal considered it necessary, a position where new proceedings are brought in Brazil against BHP PLC and or BHP Ltd by or so far as concerned CPAs on behalf of the English claimants for the same claims as are being pursued in England, including multiple new CPAs and or individual proceedings. So there are undertakings to submit in respect of the original undertakings, but also in respect of multiple new CPAs, so a CPA which include municipalities and associations, as my learned friend described, or individual proceedings, not just liquidation proceedings. And we would give the same undertaking that my learned friend gave, suitably adapted in respect of limitation for those sets of proceedings.
So we've got a range of alternatives on your case of what the alternative
Yes.
forum is, because we obviously have to look at the specifics, not just say Brazil in general.
Yes, and so
It's new CPA consolidated, alternatively multiple CPAs, alternatively several proceedings brought in the 12th District Federal Court, presumably.
or individual courts, whether by way of liquidation proceedings or individual proceedings.
Yes, they wouldn't necessarily be in the federal courts, would they?
No, they
State courts.
potentially wouldn't. They may be transferred to the federal court. Many proceedings are, because as you know, that's the court charged with the Fundau Dam litigation, unless it's a very local factor.
So you
yes.
contemplate a multiplicity of different proceedings as the alternative.
Well,
Through
our
that
evidence
route,
is
through the local court route.
I'm sorry, Will.
My fault. On this alternative, i.e. suing in the local courts, it's a multiplicity of proceedings in Brazil, not
On
a
that,
not a
but
single set of proceedings.
Yeah, but our position is on the evidence that the obvious way, and this has been addressed by Mr. Toledano, for the new CPA for the claimants to bring their proceedings in Brazil would be through a new CPA in the 12th Federal Court.
Well, I understand that. The alternative of individual claims doesn't raise the question as to whether it's an available alternative forum, but the new CPA stroke consolidation does raise the issues, because that's disputed on the expert.
Well, that's
why I just wanted to be clear what you're saying. But you're
Yes.
you're saying one or the other. Your primary case is new CPA, if not
exactly.
multiple CPAs or individual proceedings. Thank you.
Exactly. So that's for Danta, and in my submission, the following propositions which the judge correctly applied emerge from the Vedanta judgment. First, the point at paragraph 66 that the task of the court is to identify the forum in which the case can suitably be tried for the interests of all the parties and the ends of justice. Secondly, where claimants are able to avoid the risk of irreconcilable judgments by ensuring the proceedings are tried in the natural forum, that risk is relevant but not a decisive factor. It ceases to be a trump card. The reason for that third proposition is that it is the claimants who created the risk of fragmentation and thus the risk of irreconcilable judgments. And fourthly, the hypothetical predicate for the whole analysis is that substantial justice is available. So in our submission, and we set it out in our skeleton, in short, this is plainly a case where the fragmentation that the claimants are concerned about has been caused or will be caused by their choice not to institute one or more of these proceedings in Brazil, the predicate being that for the purposes of this analysis that substantial justice is available.
That all proceeds on the basis you're talking about a single claimant. How does that apply where you've got a number of different claims? Can one claimant say, well, there's a risk of irreconcilable judgments because the other claimants have chosen?
No, my lord.
Because they haven't. It's not because of their choice. You can't say to them, well, you've created the risk of irreconcilable judgments by your choice, and therefore you should be effectively disqualified
Well, there should be no risk in this case because 25 of the claimants, the municipality claimants, can bring the new CPA in Brazil, as you've heard. That would be their choice not to. They have that choice. And the remaining claimants can bring the new CPA, join that CPA by forming an association. So they have that choice and they have that control. And in fairness to the learned judge, in my submission, he clearly, correctly applied the Danta. One sees that from 241 of his judgment, where he said, and admittedly it's in summary form, but he's referring to the undertakings I've shown you to, that both defendants have offered to submit themselves to the jurisdiction of Brazil. Thus, the force of any suggestion that there may be a risk of irreconcilable judgments against each defendant is attenuated. It's not a trump card, so he's correctly directing himself in my submission. And again, taking into account the one point that the claimants essentially make under this ground, he says, notwithstanding the conspicuously close corporate relationship between the two defendants, I'm satisfied the remaining arguments concerning the appropriate forum are, when taken as a whole, so strong as to lead to no other conclusion than the first stage of Spiliada is made out. So he's conducting in my submission a perfectly proper and correct and unimpeachable legal exercise in reaching the view that the first stage of Spiliada is made out. And that's why his four concurrent factors in my submission are so important, because they are, as he rightly points out, very, very strong. This isn't a finely balanced, other than the Vedanta choice point. It's not in my submission finely balanced. So for those reasons, we submit the judge was right under stage one.
If that's a crucial document, one of your juniors should go and treat.
It's an undertaking, my lord.
Nobody
I was
noticed.
distracting you. You couldn't just get it back. Sorry, Dan. My lord, one then comes. It's just there. Sorry. One then comes to stage two. It's unfortunate you had to see behind the scenes. One then thank you, Dan. One then comes to stage two, and the judge moved on to deal with that in his judgment at paragraph 243. And essentially, as you know, he's accused of two errors of law by the claimants. The first of all is that he applied the wrong test. He didn't apply the real risk test as set out in Ultimo. He applied the test as articulated, I think, by Lord Gough in Connolly and in earlier cases pre-Ultimo. And the second is that he took into account the availability of justice as against other defendants and not against Limited and PLC. Those are the two errors of law. Dealing with the first, my learned friend's prime exhibit, as it were, is paragraph 247, where he says, I'm of the view that the claimant's evidence falls far short of establishing upon sufficiently cogent evidence that substantial justice cannot be done in Brazil. And for perfect reading, one would like that to read that there's a real risk that substantial justice cannot be done in Brazil. But in the previous paragraph, citing Lord Collins, he clearly had the proper test in mind, because he says, comity, in paragraph 246, comity requires that the court be extremely cautious before deciding that there is a risk that justice will not be done in the foreign country by the foreign court. And that is why cogent evidence is required. So I submit it would be harsh on the learned judge to assume he didn't have the right test in mind. But even if there is a question mark over that, what is clear from his reasons is that this is not a closely, finely balanced case. He makes it absolutely clear when he moves on to consider the two issues of whether delay or impecuniosity meant that there was a real risk that substantial justice would be done. his conclusions were overwhelming. In 255, he said, "I'm entirely unpersuaded that proceedings in England would be more promptly concluded than would proceedings in Brazil." And in 256, when he went on to deal with impecuniosity, before correctly directing himself in accordance with Lord Gough in Connolly, he said, referring to the fact there are some cases where impecuniosity has been taken into account, the evidence falls far short of establishing that impecuniosity would be a major factor in stifling legitimate claims. So on that point, we respectfully submit that he clearly considered on the evidence that the claimants had fallen way short of establishing that there was a real risk. If there's any doubt about that, we also have our respondent's notice, paragraphs 9 and 10, and we rely on that, and on the basis of the evidence that we refer to in our skeleton in relation to delay and impecuniosity, we say that this court can be entirely satisfied that the claimants have not come remotely close to satisfying stage 2 of Spiliada. And it does seem bizarre, and certainly this is surely an extraordinary and unique case in which claimants are saying that they cannot get substantial justice in Brazil in this instance, in circumstances where they are seeking to take advantage at the same time as bringing this claim of rights of access to the courts in Brazil, and seeking to take advantage of compensation schemes that the courts in Brazil have initiated, and in circumstances where 70,000 of them have brought proceedings and all of the facts and statistics that I brought you. This doesn't, in my submission, come even remotely close to the type of case where the courts in the past have held that there is a real risk that substantial justice may not be done. We're not in the extreme cases of corrupt regimes and such like, and the cases where impecuniosity was a material factor, the Connolly, Luby type case, the Danta type case, there was no legal aid, no CFAs, no available lawyers, clearly no real prospect of being able to mount the same action in Brazil. So in my submission, when one stands back, it's not necessary to go through the claimant's various points under one by one. We've addressed them in our skeleton. But if one looks at them, they're legal aid, points about legal aid, which are the Jano type points, which in my submission don't come close under a risk of that there won't be substantial justice limb. The funding type points, again, don't come close because we know CFAs are available and legal aid is available. The delay points, again, for all the reasons that I put before you, in my submission under this limb, do not come close. And there are then other procedural obstacles, and there's references to the 19. Again, as in this jurisdiction and many jurisdictions, I entirely accept there are those who would complain, but as this court knows well, and Lord Collins and other judges have made clear in many cases, the English court is very slow, for reasons of comity, to start becoming too unduly critical of other courts. The second error of law is that he took into account the routes to redress against Samarco, and the way that's put is that did, if you said, infect some of his reasoning. In my submission, it's clear from the judge's reasoning that, in fact, although he did start considering those routes to redress, he made it clear, as he says in 250, having said that it was relevant to consider, or he was considering under all the circumstances of the case, those routes to redress. He says, even if I were found to be wrong on this point, it would not lead me to a different conclusion. The experts are agreed that the Brazilian courts would have jurisdiction to try an action brought against BHP PLC Limited, which made the same claims as those which have been brought in the Master Particulars of Claim. The evidence relied on lacks the cogency to be expected under stage 2. So he does, in fact, then say in the alternative, I am considering the position of substantial justice against...
Do you accept the appellant's right in principle that the comparison is between the redress available against these defendants
I do.
in the alternative form?
What I do say, though, is the availability of substantial justice against these defendants is relevant to the inquiry. Against Samarco is relevant to the inquiry because it's obviously indicative of the nature of the justice system. It's not conclusive, but it's clearly when there are many claims, Fundau claims being brought against other defendants, that tells you something about the availability of substantial justice in the relevant place. And so far as the arguments in relation to CPAs are concerned and bringing CPAs and timings of CPAs, I rely on the points made by my learned friend and on the points made in the documents which has been handed up. And again, in my submission under the second limb of Spiliada, it doesn't come close when the claimant's having to resort to arguments like, well, we might be unwilling to bring them. It's just simply not at the sort of threshold that one's normally acting under this limb. So, my Lord, for those reasons, in my submission, the judge reached the right conclusions under the forum non-conveniens head, but insofar as he may have erred in law in the ways that have been articulated, we rely on our respondent's notice and the evidence that's referred to in our skeleton, and indeed that you heard me deploying before the court in relation to a number of these matters under abuse. Would you give me two? No.
I'd like, before you finish, just to go back to my point on Vedanta applying between different claimants, because I'm not sure I expressed it sufficiently clearly. If you've got a foreign forum, which all other things being equal is clearly the natural forum, what Vedanta says, as I understand it, is that isn't changed by there being a risk of inconsistent judgments if you have to go to the foreign forum whilst you've still got an anchor defendant you can sue here, because you don't have to sue him here and it's your choice to sue him here, and that's what creates the risk of inconsistent judgments. And
yes.
And the claimant can't say, well, because of that choice, I've trumped, as it were, what would otherwise be the natural forum. But if you have different claimants with their own interests and their own decision-making process, why can't a claimant say, there are proceedings which are going to take place in England against defendants here, brought by other claimants. It's not my decision, that's the decision of the other claimants. And therefore I can pray in aid the risk of irreconcilable judgments, which will arise if I have to go abroad to Brazil. So, applied to the facts of this case, could the municipalities say, well, if we were the only claimants, you might have a point under Vedanta in saying, well, we can go to Brazil, and if we continue against English defendants, or one of them, that's our choice and Vedanta applies. But the 13 large businesses are making their own decision. They've made their own decision to bring proceedings here. So far as we, the municipalities, are concerned, we're not creating the risk of irreconcilable judgments. The other claimants are. That was the point I was struggling to. I've had to articulate it a bit more fully than I.
Well, my lord, I would say no. It's not open to them to say that. That the same question has to be asked by each claimant, and each claimant should be taking the decision to avoid the type of irreconcilability which would occur if you had two major group actions on either side of the world. If you have a maverick claimant, your lordship's point might be good for one claimant. In my submission, it cannot be right that one could circumvent Vedanta and a group action simply because, for one reason or another, there will be a judgment a claim going ahead, in this case in England. One has to, under stage 1 of Spiliada, consider where the true, what is clearly and distinctly the forum conveniens is. And in this case, that is undoubtedly Brazil. We have the added factor that there is a huge amount of additional litigation already going on in Brazil. So in this particular case, the outcome of that exercise should be to ensure that this group action, the seat of this group action, is the forum conveniens, which is Brazil.
Well, I understand entirely if you treat all the claimants as one, but...
well, either one keeps them as one, which would be which is a legitimate approach in my view. But even if one doesn't, I would still say, even if you take them individually, in circumstances of this case, it does not lie in the mouth of individuals to circumvent the whole purpose of the Vedanta choice point by saying, well, there happens to be one person suing, or 2 people, or 10 people, so 200,000, therefore make a different choice. It seems perverse in my respectful submission. So, my Lord, that would be my answer to that point.
And you were asking for 2 minutes. Were you asking for 2 minutes just to be look behind you, or will you have an extra point you want to make?
An extra point, if I may. It'll take about 2 minutes. Is that possible?
Yes.
The first is maybe 3 minutes. My first is Lord Justice Popplewell's point, which is the Caliph 1 point. Is there any further evidence in relation to the point you raised? And the relevant evidence is in Caliph 1. It's your Lordship's certainty point. My short answer to the certainty point is the fact that, as you've seen from paragraph 23 of Caliph 1, settlements in the novel system are ratified. So whatever appeals may be going on, and I accept there are appeals by the companies which are referred to in 27.3, as I told you in relation to the novel system, there's some appeals in relation to exactly what the cut-off date should be. The fact is it's been open since October the 30th. It is open at the moment until April the 30th. If the claimants were to make use of it, they would have a settlement agreement ratified by the 12th District Court and by Judge Mario.
But I thought there was a challenge to the jurisdiction. The whole structure of the novel system was being challenged.
Well, my instructions on that point are that if an individual claimant has an agreement ratified, i.e. the 67,000 we have, which is growing, that it is just not feasible for those to be unravelled, whatever happens in this jurisdiction, which would seem an extraordinary state of affairs that as a result of an appeal, you could unravel 100,000 ratified settlements. I'd be very surprised if there's any serious argument about that. So that's my answer to that point, my Lord. My Lord, could I just say this on abuse, if I may? My Lords, my Lady, I've made my submissions about the defendant's position on pointless and wastefulness, and we focused on the position if the claimants succeed compared to the respective positions in England and Brazil. Well, I haven't focused much, but there's no need for me to. It's a fortiori, the other side of the coin, if the claimants fail, as the judge noted. I dealt very briefly with the jurisdiction issue, but just to, if I may underline again that our argument is planked on non-jurisdictional factors and other defendants who are not denying liability in the schemes, the Wyeth analogy, the Wyeth position by analogy. But there are clearly issues that are of concern to the court, and if I may say so, the court has very helpfully made clear that it has been cogitating certain issues in relation to the 13 limitation and so on, and it's fair to say, and I obviously make no criticism whatever, that a number of points have been raised which were not pursued below or not taken by the claimants on this appeal, and my Lord Vice President has asked me whether there are any questions in relation to whether there are cases closer to our situation, and I've stressed the uniqueness of it and the fact that it's probably a mixture of Wyeth, Jamil and Binns. The claimants have offered undertakings. I understood they'd been withdrawn or may have been withdrawn, and I understand there's a lot of...
It's becoming rather a big point. Is this sort of preamble?
There's a preamble to this.
To what?
These moving parts and this uncertainty. Just 2 points, if I may. In my submission, these uncertainties are met by a stay, and you have my points on that.
Yes.
But if the court considered it appropriate to make a stay, but subject to certain conditions affecting both parties, I just wish to make it clear that that is obviously something that we would invite the court to give careful consideration too, and could be the subject of a consequential hearing if that would ensure that matters were the subject of proper submissions in due course. And equally, if the court would be assisted in any respect by me taking instructions in relation to any matter that would assist, that is again something I don't want it to be thought that is not open.
Thank you.
Thank you.
Very well. We will say 2:10. That I do appreciate Mr. Choi cuts into your reply by 10 minutes. I doubt if that's going to be a serious constraint. If it is, we might show the same indulgence to you as we've shown to Mr. Gibson, but it won't be very popular having to do so at 4:30. Let's see how we go.